May I please, Your Lordship? Charge-sheeted matter, Lordship, and may I pray for
Record.
PCR, Lordship,
Yes,
record,
yeah.
Lordship.
When? From where it will come?
Lordship, it will come to Metro, Lordship.
Kamrup Metro. When?
September to the second week. Second week. So with the NBS commercial, Lordship, it will take time. So September 2nd.
Okay.
7. Much obliged, Your Lordship.
May I please, Your Lordship?
Yes.
My Lord, this is a regular bail application, my Lord, and this is a clear case of illegal detention, my Lord. My Lord, we are not named FIR, not named in the FIR. My Lord, may be pleased to find the FIR is at page 15, my Lord.
Regarding the other accused by the similar PS case number, but listed on 31/7/20, and today that's listed. But in that case, although case was not called for order, the order was not uploaded. I have today morning I have received the CD number. So my period equal to what? In that case,
No. In that matter, CD was not called for. There we will pass the order today.
My Lord.
So okay, we will peruse the case, then we'll pass the order. Then
My Lord,
how the detention is illegal?
Illegal, my Lord.
How?
My Lord, because my Lord may kindly turn to my Lord regarding that requirement of section 35(3) is at page 20, my Lord, in the reason of arrest and ground of arrest which had been explained. My Lord, it had been found. Lord, if the arrested accused persons are released as per notice under section so and so, they may hamper and tamper with the evidences of the case, threatening the local witnesses, and also may abscond, and their production in the honorable court during trial cannot be ensured. Therefore, the persons were not released on notice under section. So, my Lord, it's clear that no such notices had been issued, my Lord. This is the reason which has been, my Lord, incorporated by the investigating officer, and my Lord, when we preferred a regular bail before the learned trial court below, my Lord, that my Lord part had been taken care of. My Lord may be pleased to find the page 53, my Lord. Page 53. I am reading from, my Lord, the second paragraph, my Lord. Page 53. May I read, my Lord?
Yes.
The forwarding report and the case diary further discloses that the investigating officer has recorded detailed reason for the arrest as required under the BNSS. The reason specifically indicate that custodial interrogation was considered necessary to ascertain the modus operandi of the organized cyber fraud, identify and apprehend other members of the network, recover the proceeds of the crime and additional electronic evidences, prevent the destruction of electronic and documentary evidence, prevent influencing of witnesses, and prevent the accused persons from absconding. The investigating officer has also recorded a specific reason for not issuing notice under section 35(3) of the BNSS, stating that release of the accused on notice was likely to prejudice the investigation by facilitating destruction of evidence, influencing witnesses, and absconding. Upon an independent examination of the materials available in the case diary, I find that the reason recorded by the investigating officers are neither mechanical nor arbitrary, and this stage disclose due compliance with the mandate of section 35 and 36 BNSS. Prima facie, the arrest cannot be said to be illegal, and rather they have been effected on reasonable and cogent reasons. My Lord, this is an absolutely mechanical finding. My Lord, no reason has been cited that what are the materials, my Lord, had been collected by the investigating officer. My Lord, this is purely on presumption and assumption. My Lord, may kindly peruse the operative part of the paragraph. The investigating officer has also recorded his specific reason. Now, my Lord, basing on what material, my Lord, they have been collected, that this is not required is missing, my lord. And this has been clarified. My lordship knows, my lord, that my lordship has already passed an order regarding this issue. My lord, in this Satendra Kumar Patil's until judgment, my lord, our copy not available. Ready? My lord, for this submission, my lord, I may be, my lord, I am relying on the paragraph 27.8.2, my lord.
Yes, and not necessary to.
My lord,
cite it,
yes, my lord, my
okay.
lordship has already relied on and has gone through. So therefore, my lord, my respectful submission before my lord is that, my lord, that the mandatory requirement under section 35, my lord, this and 36, my lord, has not been complied with, it only presumption and assumption, my lord. So which is not sustainable in law, my lord. So therefore, in view of the, my lord, various judgment passed by the Honorable Apex Court regarding the life and liberty under Article 21, my lord, in such a manner, my lord, it cannot be, my lord,
Okay.
curtail, my lord. This is my limited
Okay,
submission.
Mr. Bordakore, please,
Yes, my lord, cyber-related financial fraud, my lord. They are from the order. of
no,
the
that's
trial
all right.
court.
He is not on merit. He is on the.
My lord.
Regarding that also, my lord, specifically from the order of the trial court reflects that is not on satisfaction of the IO. Thereafter, not only the satisfaction of the IO, satisfaction of the learned trial court on the basis of the materials available on record. These are serious cases of cyber financial.
Okay, we
fraud,
will
my
examine.
lord.
You hand over the case diary.
What more is required?
Okay,
My lord, constitution is above all, my lord.
yes,
My
right.
Obliged, my lord,
Next.
deeply obliged.
But the same PS case, same forwarding report, but on the same grounds. Only, what I would, submit, the lordship has considered this issue, way back in 2023. And considering that, the order dated 18/10/2023.
Okay, okay. Okay, we'll see the case diary also. We'll pass the order.
And the judgment of the, that recent judgment of this.
Not necessary.
Until.
I know about it.
Lodge.
Next.
My lord, regarding the same affair. Lordship has
Yes,
heard at length, my
but
lord.
this petition is allowed.
Deeply obliged.
Regarding that aspect, your lordship. My lord, from the materials available on the honest.
So, no, in respect of other accused, we will examine independently.
Regarding the present accused also, your lordship may kindly proceed once, my lord.
No,
From the materials,
no.
because compliance of Ernest Kumar is also.
No, that was not argued on merit of the case.
On merit or on the compliance.
We will not look into the merit of the case.
Yes, regarding compliance of 35(3) also.
No, we have allowed this petition.
Obliged.
Petitioner was arrested on 2/6/2026 on the allegation of certain sections under the NDPS Act. So I pray, this CD may be called for.
It is in investigation stage. Investigation stage.
Lodge.
Okay. When he was arrested?
2/6/2026.
From where CD will come?
CD will,
Digboy.
police.
Digboy.
PS.
Okay.
51.
Portakor, when?
He is a doctor by occupation, certain drugs were found, in his clinic as the component were, bupropion.
Whether
So-
he is involved in earlier cases?
No, not at all. What they in the forwarding report, you'll also will find, they have said that my clinic is a pharmacy. But pharmacy is a
Okay.
different concept, and my, I am a
Let the
clinic.
CD come on
On my lord.
18. Okay. 18th of August.
Can there be an earlier date,
Earlier that I have no problem, but the problem is with him, whether he will be able to produce it
nowadays
or
all
not.
electronic modes, everything, if it can be around 13/8, at least.
13.
Yes,
13.
Before 15 August, again, not reach
13.
big difficulty. So.
Maybe that cannot be the
Yes.
ground. Huh?
Yes.
Authorized.
Number 4. May I please, your lordship. So an anticipatory bail application, lordship, will kindly find the FIR in page 23, lordship. I am not named in this FIR. So lordship, what has happened here? Some sort of irregularities kept up in AFDC fund. Assam Assam Fisheries Development Corporation Fund. There were some accused already named. I have done some work admittedly out there as a contractor. My name doesn't figure here. Now what happened, your lordship will kindly see. Item number 4 also, my lord, there are other matters, item number 31 and 32, my lord. I am not aware. 10 city, my lord.
You have received the CD. You received the CD.
Yes, regarding item number 31, 32 today, my lord, those matters were listed.
At 2 p.m. Okay, at 2 p.m. All right. Okay. Give the item number to court master.
May I please, your lordship?
Mm.
My lord, kindly take this item along with item number 17, my lord.
Okay.
My lord, kindly take the item number 17 first, my lord.
Yes.
Same petitioner, my lord.
So when the case was registered, before 2023.
My lord.
Okay.
My lord, kindly take the item number 17 first, my lord.
Item number 17.
My lord. Same petitioner, my lord. One, I have filed a criminal petition for quashing of the order for issuing the proclamation of arrest. And item number 5 is for anticipatory bail application. My lord, here, my lord, the FIR will find at page number 20, my lord. Page 20, my lord. There are all total 4 accused persons. And against the accused number 1, my lord, an allegation of section 376 and 447 has been registered in the name of Shahjahan Ali, and remaining 3 accused persons, my lord, against them, my lord, section 120B and 34 has been surceased, my lord.
Okay. You say to deal with this application for bail,
My lord,
we have to go through the record.
my lord.
Let the trial court record come. It is surceased case
Surceased matter, my lord.
pending before.
My lord, kindly peruse the order of the pending before the Chief Judicial Magistrate, Tezpur, my lord.
Tezpur.
Tezpur.
Okay, let the trial court record come
My
in
lord,
this matter.
my lord, only the thing is that the next date is fixed for appearance. There are all total 4 accused persons. 3 accused persons are already on bail. Against the present accused petitioner, my lord, while the investigating officer submitted the search sheet, he mentioned my police station address as Hekiazuli police station. I have annexed the voter ID card of the present petitioner. His police station is, my lord, Bihoguri police station. So thereby, my lord, when the summon has been issued, bailable warrant has been issued, non-bailable warrant has been issued against the present petitioner, it is in the record, my lord, order that cannot be executed. Because of the, my lord, the error made by the investigating officer, that I do not fall under the jurisdiction of Hekiazuli police station, my lord. So thereafter, my lord, when the proclamation of arrest, it was issued on 25/6/2026, my lord. And thereafter, I filed a bail application before the learned session judge, my lord. And that has been rejected only on the ground that the proclamation of arrest has been issued against the present petitioner.
Okay, we'll
Only,
see
my lord.
let the record come. Record of what is the number of the case?
My lord.
PRC case number 875 of 2023, arising out of Hekiazuli PS case number 106 of 2022 under section 477, 376 IPC from the Court of Learned Chief Judicial Magistrate, Tezpur, Sonetpur on
My lord, may I pray on 18, my lord?
18.
18.
Okay, 18. In other matter, also we will look into the case diary and the record.
My lord. From the record, my lord, I have annexed the search sheet and cognizance order. Only section 120B
Against you.
against me. My lord.
Okay. Where is the impugn order in this criminal petition?
Criminal petition, my lord. Impugn order is page number 37, my lord.
37.
Order dated 25/6/2026.
Heard Mr. Hallowell, learned counsel for the petitioner, and also heard Mr. Portaco, learned additional PP for the state respondent. In this petition under section 528 of the BNSS 2023, the petitioner has right for quashing the order dated 25/6/2026 passed in PRC case number 875 of 2023 by the learned additional Chief Judicial Magistrate Sonitpur, Dashpur. It is to be noted here that by the impugn order dated so and so, the learned additional Chief Judicial Magistrate had issued proclamation and attachment against the petitioner in a proceeding drawn under section 120B stroke 34 IPC. After hearing learned counsel for both the parties, perusal of the trial court record is found to be necessary, and accordingly it is provided that recessal call for the record of the learned trial court fixing the matter on 18.
18, my lord.
18. Further, considering the submission of learned counsel for both the parties and also considering the impugn order dated 25/6/2026, the same instance state till returnable date.
Highly appreciated.
Number 6.
May it please, Lordship. My Lordship, for Lordship, a clearance bail application, Your Lordship. This is FR is at page 9, Your Lordship.
POXO is there.
POCSO is there, Your Lordship, but I'm not named in the FR, Your Lordship. And
Maybe notice has to go here.
Lordship, a similar order been passed, Your Lordship. Similar order been passed, granted bail, Your Lordship, to the co-accused person. He's also not named.
No. Without issuing notice, can we pass the order?
No, Lordship, POCSO is there. POCSO
Then?
is there.
This application under section 482 of the BNSS 2023 is preferred by applicant. Mohanto Kumar Mandal, who has been apprehending arrest in connection with Manipur PS case number 39 of 2026 under section 87, 127 within bracket 2, 64 within bracket 1, 61 within bracket 2, within bracket small a, 336 within bracket 2, stroke 49, and section 3 within bracket 5 of BNS, and section 4 and 17 of POCSO Act 2012, and section 9, 10, and 11 of PCM Act 2006. Let notice be issued to the respondent number 2, returnable in 4 weeks. 4 weeks or 2 weeks?
A date may kindly be given, a short date may kindly.
After this 15th of August.
21st of
21st of August.
21st of August. Is to be taken through the office of the public prosecutor, Guwahati High Court.
One is for my knowledge.
And on that day, Mr. Portakur shall produce the case diary before this court and also produce the service report upon the respondent number 2. List accordingly.
Obliged.
7.
May it please your lordship. My lord, here page 11 is the FIR, my lord. Page 11 is the FIR, my lord. I am Rohan Ali, my lord. Actually, my lord, what happened, my lord, there are many cases filed against the informant family against them, my lord. In one of the cases, my lord, this is the case of 2025. And my lord, on my lord, I have annexed one order, my lord, of this honorable court.
Yes, Mr. Bortakar.
May I pray one thing, my lord? Page, Lordship may kindly turn to page 14.
Didi.
Page 14, my lord, page 14 once, my lord. But there was a similar type of case, my lord, by the same my lord, informant's family, my lord, was lodged against the petitioner, my lord, and others, against his brothers and others, my lord. In that case, my lord, I was granted interim. This is the 26th case, my lord. And that case in which I am seeking bail is 2025 case, my lord. I went there, police station, I recorded my statement, my lord, and my interim bail was made absolute, my lord, while order dated 28/7, my lord. Now, my lord, now, my lord, after that, my lord, in this case, 2025 case, my lord, I have been charged, my lord. That is a different case, my lord. But my lost by the same family, my lord, informant's family, my
No,
lord.
each case has to be decided on the basis of.
Yes, my lord, but my lord, there are
own
false
facts.
cases lost against us, my lord, many false cases, my lord.
We'll fix a very short date. Let the city come. Bortakar. 11th. 11th. CD on 11th.
May I please, your lordship?
Hmm.
Lordship, the instant petition is against the order of the learned trial court, wherein after the filing of the FR by a final report by the CBI, the learned trial court issued notices for cognizance. Lordship, I'd like to just produce three things. My challenge is on the ground that first the FIR was lodged by the was lodged, and there is a document on record which the police had, which said that it was during the line of duty. So prosecution sanction was not there. That apart, the learned court below, the FR categorically discussed every aspect of the investigation, why the FR was filed. That I'll show your lordship. And thereafter, it was recommended to file FR. In spite that, the learned court below, without any materials on record, without considering the valid points like the FR itself discloses that the complainant said that the FIR was lodged at the behest of some other persons. Now, the background of the whole story is that it is regarding that violence, regarding Manipur violence, where there was a clash between the Meiteis and the Kukis. So my client is a Kuki, belonging to the Meitei Kuki client. So the Meiteis had attacked the house of my client. So this was basically, may I take to the FIR first, lordship, which is at page 20. Lordship has got it?
Page number?
20. 20.
Yes.
Lordship, I read. I have the honor to report that on 12/5/23 at around 12 noon, I was physically assaulted by one person, namely Daniel Hamar, aged about 35 years, serving as assistant commandant in CRPF, such and such, Hamar of Sangrupro Maulang, the name, wearing in full uniform, guarded with his personnel by slapping, punches, etc., and kick in my private parts. Also, while I was seated in front of my shop come house along the roadside of TDM Road. Besides this, one of his guard personnel have pointed out his service gun to me, as a result of which I received injury on my body and evacuated to RMS hospital for medical treatment by the member of our local club. It is therefore requested to kindly take up the necessary legal action as per law. This is the FIR which was lodged by the complainant, the victim. Lordship, may then be pleased to come to page number 47 for a moment. 47. What happened that he was arrested? He was taken to the police station. Then there was a signal report sent by because he's a deputy commandant of CRPF. Page 47, Lordship has got it. Lordship 47.
Got it.
47, may I read, Lordship? Regarding the incident dated 12/5/23, on 12/5/23 at about 11:30, a party comprising such and such was detailed under Commandant Daniel Hamar, that is the petitioner, on bona fide government duty to collect number such and such, Suren Boro of such and such, who was scheduled to return, scheduled to reach Imphal Airport by Dimapur Imphal flight by airlines such and such dated 12 May 23. Daniel Hamar, AC, who is the commanding Charlie Co of such and such, is to supervise the development of his section developed at various locations in Imphal. On the way to airport, when the party reached Shanghai Pro Imphal, Sri Daniel Hamar halted to check his house, which was damaged and looted on 4th May. During the ethnic rites and to collect itself items, if any, left on the back side of the house. While inquiring about the incident, one boy about 25-26 years started arguing and scuffled with Daniel Hamar. AC, when our troops intervened, the said boy tried to escape and fallen down and sustained minor injury. Our troops, along with Daniel Hamar, returned to his house and collected the articles of use. By the time police personnel came on the complaint of local Métis people, and matter was blown out of proportion due to the ongoing law and order issue, Daniel Hamar, along with such and such, was taken to Imphal police station and was lodged as such and released by PR bond by such and such. So this is on duty. This is a specific line given that he was on duty. Lordship may keep this in mind for the time being. Then what had happened thereafter is that the CRPF conducted an inquiry, and it is on the part of the FR where what happened to the inquiry. Lordship may be pleased to come to page number 37.
Mr. Das, whether record will not be required here?
Lordship, records will be required, but I'm praying for the stay. Because here the prosecution sanction is not there. I will show, Lordship may just be page 37. I'll show the FR itself says why they had filed this FR. There's a detailed investigation. But in spite that the magistrate went. Now, I ask myself this question, whether a magistrate could have passed an organization order without the prosecution sanction. The page 37, number 15. 37, number 15. Lordship has got it? During the course of investigation, documents related to day-to-day inquiry conducted against Sri Daniel Hamar, the deed and assistant commandant, and Sri Manohar Singh, the deed and inspector such and such, along with his final result was also sought from CRPF, which revealed that during the aforesaid inquiry, CRPF officers came to the conclusion that the FIR dated such and such and FIR dated such and such was filed by the complainants of the said case on the basis of false allegation. Based both on aforesaid officers were found not guilty in the court of inquiry. There was a court of inquiry also. And Lordship, regarding the FR, Lordship may come to page 43. I'm not going into the details of this. It has discussed every aspect. Page 43.
Yes.
In this way, 3 lines of action were produced in this case. The first involved collecting evidences against alleging offences under section such and such through various oral and documentary evidence, but the said allegation could not be proved beyond reasonable doubt due to the following reasons. There are contradictions between the statements of the victims and the eyewitness regarding the allegation of kicking and touching of a gun to her chest. Additionally, there are discrepancies about the unknown co-accused. Furthermore, eyewitnesses, Mrs. Such and such, stated that she saw 3 persons in army camouflage uniforms crossing the foot passage quickly and approaching the victim and Pushpa such and such, but she identified Mr. Daniel at the instance of other local residents of that area, as she did not meet or never saw Daniel. During medical examination, alleged history of patient was documented as physical assault by known person at somewhere such and such. Dr. Sweta Mishra stated the victim did not report any type of sexual assault. That was the allegation. She did not mention being kicked in or her private parts or experiencing any part or injury in that area. That is the FIR, Lordship. FIR clearly said that I have been assaulted. Witnesses, including the victim lady, stated that at the time of assault, Mr. Daniel was addressing the victim lady as HA.
Where is the impugn order?
Impugn order, Lordship, starts from
51.
page 51. The FIR was lodged under 354, 34, and 27 Arms Act. That we can see in the 1, 2, 3, 4, 5, 6th paragraph. The FIR in this case was registered. Lordship has got it. Now, the magistrate, in spite of sufficient incriminating materials, the IO Srimati Reena Chauhan, Inspector of Police, Cybercrime Investigation, Delhi, has filed a closure report stating that the investigation could not establish the allegation under 354, 34, and 27 beyond reasonable doubt against the FIR name accused Daniel Hamar. Then the learned court below goes on to discuss about the law regarding whether the acceptance of the FIR is permissible by the magistrate, which is not, there is no dispute to that thing. From page 53 is her application of mine. Page 53, Lordship may please. Lordship, after the italics part, from the above guidelines, Lordship has seen. From the above guidelines, it appears the magistrate is not under every obligation to accept the final report. No quarrel on that. If he does not agree with the opinion of the police, the power to take cognizance, notwithstanding the formation of an opinion by the police at the final stage, has been provided. Again, no quarrel. From the materials available in CD, it appears that despite explicit materials against Daniel Hamar, the deed and such has filed a closure report best known to the IO. In view of the discussions, now the FIR changed, the 354 changes to 323, 323 is also added. Now, when there is a specific part that the victim herself said that she has not been physically assaulted, the ingredients of 354, I asked myself the question, where was the material satisfaction by the magistrate that, yes, they were incriminating materials. Yes, the IO were totally wrong in filing the closure report.
No, in the FIR, it has been mentioned.
Yes, but when the FR was filed, I have read, now I'll read, I've just read
Not necessary to read it out.
I have not read the.
Whether after bare perusal of this FIR, it can be said that no offense under section 50.
FR has been filed by the, FR has been filed, a closure report.
Maybe.
Once the closure report, now the FIR.
No, a magistrate is not bound by the closure report.
No quarrel on the magistrate has to go on the evidences on record.
Yes.
If the trial proceeds, what is the evidence on record? The evidence on record is saying the victim is saying that I have not been sexually assaulted.
Where it is stated?
Lordship, it is the victim who is stated. This is the part of the FR. It's part of the FR.
No, we will examine the.
No, Lordship,
record.
that examination may, that I am not, here victim.
No, stay at this stage.
Lordship may just come, page 33.
Sorry, no, stay at this.
Lordship may just for.
We'll see the record.
Lordship may see the record.
Yes.
I'm not, Lordship may come at page 33 for a moment. 33 for a moment.
Yes.
Point number 4. During investigation, on being asked, victim lady stated that Daniel did not touch her in a way which showed that his intention was to molest her or harass her sexually.
No, we see whether it is based upon any materials, any statement of the victim or not.
This is based on the, Lordship, when this is a part of the FR.
No, maybe.
Not Lordship, when this is a part of the FR, then Lordship may give a short date because because the it's not fixed on 18.
Learned counsel for the petitioner. Mr. Kumari, learned standing counsel for the CBI. In this petition under section 438, read with section 528 of BNSS 2023. The petitioner has spread for quashing and setting aside the impugn order dated 2/1/2025 passed by the learned Chief Judicial Magistrate Kamrup M. Gauhati in CBI case number RC 0562023 S0015, which indicates here case number 34 of 2025. It is to be noted here that by the impugn order dated so the learned trial court. No, learned Chief Judicial Magistrate took cognizance of the offense under section 323, 354 IPC against the present petitioner and issued summon to him. The petitioner has also prayed for quashing the entire proceeding arising therefrom. After hearing learned counsel for both the parties, it is provided that registrar shall call for the scan copy of the record of CBI case number so and so from the Court of Learned Chief Judicial Magistrate Kamrup M. After hearing learned counsel for the petitioner, and also considering the impugned order dated so and so, this court is not inclined to grant any interim pair at this stage. Based on
Allowed to deal with the pathways, like, if
13. Okay.
13.
The learned standing counsel for the CBI may file or reply.
much of it.
Deeply obliged.
Made. First, the revision against conviction in the petitioner obtained.
Report noted.
What report was called for?
Lordship, regarding the interim custody of some petroleum products. which was-
Interim custody. Report was called for. Report has not been received.
Not received.
Heard, Mr.
You can't.
Learned counsel for the petitioner and Mr. Borthakur, learned additional PP for the state respondent. Mr. Borthakur submits that a report was called for from the Dhupdara police station in connection with the seizure of petroleum products in this case. But the said report has not been received. Then he prays for granting him some time to produce the same. Pair allowed, list the matter on Friday? 12.
Objection.
The revision against conviction. The petitioner is a lady, she was convicted on section 324 and sentenced to undergo imprisonment for 1 year. She is on bail also. So basically, she was convicted on the basis of some documents which were exhibited for the first time by the
Exhibited?
lordship.
Exhibited?
Exhibited, medical documents were exhibited by the victim for the first time during trial at the time of examination. Those were not seized during investigation, neither the doctor was examined to prove those documents. Those documents were under objection at the time of exhibit.
Heard
Oh.
Mr. J. Alam, learned counsel for the petitioner, and Mr. Borthakur, learned additional PP for the state respondent. In this petition under section 442, read with section 528 of the BNSS 2023, the petitioner has challenged the judgment and order dated 6/7/2026 passed by the learned additional session judge number 2, Kamrup M. at Gauhati in criminal appeal number 27 of 2025, arising out of GA case number 1347 of 2010. It is to be noted here that by the impugned judgment and order dated 6/7/2026, the learned appellate court has dismissed the criminal appeal preferred by the present petitioner and thereby upheld the judgment and order of conviction dated 7/2/2025 passed by the learned judicial magistrate first class Kamrup M. Gauhati. It is also to be noted here that by judgment and order dated 7/2/2025, the learned judicial magistrate first class Kamrup M. Gauhati has convicted the petitioner under section 324 IPC and sentenced him to suffer simple imprisonment for a term of 1 year and also to pay a fine of rupees 5,000 with default stipulation. Peruse the petition and the documents placed on record and also peruse the impugned judgment and order dated 6/7/2023 passed by the learned appellate court and also the judgment and order dated 7/2/2026 passed by the learned judicial magistrate first class Kamrup M. and Gauhati. Issue notice to the respondents returnable in 4 weeks. However, no formal notice is required to be issued since Mr. Borthakur entered appearance and received notice. However, extra requisite copy of the petition be furnished to him during the course of the day. Recess will call for the record from the learned First Appellate Court and also from the learned Trial Court. And further, considering the facts and also the circumstances on the record, the pending disposal of this review petition, the impugned judgment and order dated so and so passed by the learned First Appellate Court, and also the judgment and order dated so and so passed by the learned Judicial Magistrate, First Class Kamrup M, Gauhati, stands state. List of for weeks.
But we are allowed to remain on previous.
11.
Well, it's a revision against conviction, my lord. The petitioner, he was convicted under section 7(1) of the essential commodities by the trial court for 1 year. And on appeal, my lord, it was reduced to 3 months, my lord. These are, my lord. And against that, my lord, I prefer this revision. A very basic, my lord, one of the very basic point, my lord, we have raised before the appellate court also, that, my lord, registered cooperative society is a cooperative society without making a registered cooperative society a party, my lord, without responsibility of vicarious liability is defined, my lord, conviction has been passed. So that was the point, my lord, has to be examined, my lord. Because cooperative society is not made a party. Directly, I am the secretary.
No, this is a criminal case.
My lord, in a cooperative society, yes, in a Anita Handa's case, my lord, when, my lord, this is a corporate liability by the committee, not by a single person, my lord. Because I am the secretary, and, my lord, my liability has to be fixed, my lord. So that is one of the point, apart from other point, my lord.
Okay, we'll
My
see.
lord,
Heard Mr. T. Monto, T.J. Monto, learned senior counsel assisted by Mr.
T. Gogol.
Learned counsel for the petitioner, and Mr. Borthakur, learned additional PP for the state respondent. This application under section 442 read with section 438 of the BNSS 2023 is directed against the judgment and order dated 4th of May 2023 passed by the learned subdivisional judicial magistrate Bokakhat in CA case number 1 of 2016, whereby the petitioner is convicted under section 7 within bracket 1 within bracket small a within bracket Roman 2 of the Essential Commodities Act 1955 and sentenced them to suffer simple imprisonment for 1 year each and to pay a fine of rupees 5,000 with default stipulation, and also the judgment and order dated 12/5/2026 passed in criminal appeal number 27 of 2023 passed by the learned session judge Gulaghat, partly allowing the appeal referred by the petitioner and thereby upheld the conviction but altered the sentence
3 months simple imprisonment.
sentence to simple imprisonment for 3 months. 3 months.
Fine even saying.
Peruse the petition and the documents placed on record, and also peruse the impugned judgment and order dated so and so passed by the learned trial court and also by the learned first appellate court, learned appellate court. Issue notice to the respondent returnable in 4 weeks. Step be taken by state post and also by usual process within a week from today. However, no formal notice is required to be issued to the respondent number 1 since Mr. Borthakur entered appearance and received notice. However,
On number 2.
extra requisite copy of the petition be furnished to him during the course of the day. Rest shall call for the record from the learned tribunal. Learned trial court and the appellate court until disposal of this petition.
My lord,
The
actually,
impugned judgment and order dated so and so.
I file a miscase, my lord, for suspension of the sentence.
Stance state till disposal of this petition. the petitioner is allowed to remain on previous bail. In view of the order passed in the criminal petition number 3800 of 2026, this IA stands closed.
My lord, deep blue.
Please, your lordship, it is a revision against order of the appellate court lordship, wherein the appeal of the petitioner was partly allowed lordship. Previously in the trial court, it was 6 months imprisonment, then now 1 month imprisonment lordship.
Heard, Mr.
P. Wood.
Bordoloi, learned counsel for the petitioner, and Mr. Borthakur, learned additional PP for the state respondent. In this petition under section 438, read with section 442 of the BNSS 2023, the petitioner, namely Dhrubajyoti Kolita, has challenged the judgment and order dated 38/6/2026 passed by the learned session Judge Baksa, Mosolpur in criminal appeal number 29 of 2025, whereby the learned appellate court has partly allowed the appeal by altering the conviction from section 341/325 of IPC to section 341/323 IPC, and reduce the sentence to 1 month to simple imprisonment for a period of 1 month, and also to pay a fine of rupees 5,000 or 500
500.
with a default stipulation. And also to undergo simple imprisonment for a period of 15 days under section 341 IPC. And simple imprisonment for a period of 1 month, and to pay a fine of rupees 6,000 with a default stipulation. To undergo simple imprisonment for a period of 1 month under section 323 IPC. And also challenge the judgment and order dated 18/11/2025 passed by the learned additional chief judicial magistrate Baksa in PRC case number 405 of 2021, whereby the petitioner was convicted under section 341 and 325 IPC, and sentenced him to suffer simple imprisonment for a period of 1 month and to pay a fine of rupees 500 each in default of payment, to undergo SI for a period of 15 days under section 341 IPC, and also sentence him to undergo rigorous imprisonment for a period of 6 months and to pay a fine of rupees 10,000, and with default stipulation under section 325 IPC. Peruse the petition and the documents personal record, and also peruse the impugned judgment and order dated so and so passed by the learned appellate court and also by the learned trial court. Issue notice to the respondents, returnable in 4 weeks, step be taken by speed post and also by usual process within a week from today. However, no formal notice is required to be issued to the respondent number 1 since Mr. Borthakur entered appearance and received notice. However, extra requisite copy of the petition will be furnished to him during the course of the day. Recess will call for the record from the learned trial court, and pending disposal of the appeal, disposal of this petition, the impugned judgment and order dated so and so passed by the learned trial court and also by the learned appellate court stay till disposal of this petition, and the petitioner is allowed to remain on previous bail. In terms of the order passed in this revision petition, I criminal number 764 filed by the petitioner stands closed.
Oblige, your lordship.
May I please, your lordship? Lordship, kindly find the impugned order at page 23, your lordship. Your Lordship, the petitioner vehicle had been seized by the police personnel in connection of Gosaigao PS case number 336 of 2026 on 28/6/2026, Your Lordship. Lordship, find the order. Last paragraph, Your Lordship. At page 23. May I read it?
So after consideration of the report of the IO, the trial court has dismissed your application.
Yes, Your Lordship.
What wrong with this order?
Because, Your Lordship, the trial court has been given opinion that at this stage is likely to be adversely affect the ongoing investigation.
Whether investigation is completed?
Now is a 37 days, Your Lordship. That a vehicle
No,
has
no,
been,
you
at-
answer my question, whether investigation is
yet not
completed,
such it not filed.
not filed. Mr. Bhattakur,
I will have to get a fresh report.
you obtain a report
Fresh report like that.
Short date.
regarding the requirement of the vehicle. In this petition, heard Mr.
S.I. Akan.
Learned counsel for the petitioner and Mr. Bhattakur, learned additional PP for the state respondent. In this petition under section 528, read section 438 and 442 of the BNSS 2023 is directed against the order dated 13/7/2025 passed by the Learned Subdivisional Judicial Magistrate M. Gosaigao in Gokhaigaon, Kukrazar in Gokhaigaon PS case number 136 of 2026. It is to be noted here that by the impugn order dated so and so, the learned trial court has rejected the petition filed by the petitioner seeking custody of a vehicle bearing registration number AS01UC6232. After hearing learned counsel for both the parties, it is provided that Mr. Bhattakur shall produce a report from the concerned IO regarding the present status of investigation and also the requirement of the vehicle in the interest of investigation. List the matter on. Bhattakur, report. Gokhaigaon. Gokhaigaon. When?
13.
13.
Lordship, can it be so very short date because vehicle is kept an open
Okay.
near Your Lordship and the owner is the vehicle is the only source for livelihood of the petition. Otherwise, Your Lordship, as per the I have cited the ground in the Your Lordship, the judgment Sundar Bhai Umbrella Desai's judgment also.
No, that is there. But police report indicates that the owner of the vehicle could not be ascertained.
Yes,
Then
Lordship.
on 10, 8.
Deeply appreciated.
Item 14.
That impugn order is placed 10 minutes, 11%. Here I file a NI case in the court below against the accused person. That is appearing and he file a revision in this case, High Court. And during
So,
the petitioner revision,
Mr. Rashid,
my lord,
the case was fixed on 8/5/2026.
my lord,
You failed to appear before the court on that day.
my lord,
Therefore, it was dismissed.
dismiss, put it.
So, how they say impugn order is illegal? How?
Actually, my lord, whatever earlier, there is another criminal petition is pending that is filed with the accused person before the court, my lord. I have mentioned. And so, my lord, I could not appear, my lord, and that is dismissed. So, my lord,
Why you could not appear before the court on that day?
on that day, my lord, actually, another case was filed, criminal
Where?
petition by the accused person in this honorable court.
This court.
This court, my lord.
Maybe that cannot be the ground for remaining absent before the trial
Yes,
court.
of course. And I have instructed my advocate, also I also could not appear, and my also advocate also could not appear on that day. I have mentioned in the ground, my lord. So, my lord,
Better you go and file an application before the trial court. citing the reason for which you could
For
not
restoration.
appear
For restoration.
before that court on that day, then the trial court shall consider the same in accordance with law.
My lord.
Heard Mr. Rosid, learned counsel for the petitioner, and Mr. Porthakur, learned additional PP for the state respondent. In this petition under section 438 422 BNSS 2023, the petitioner has challenged the legality, propriety, and correctness of the order dated 8/5/2026 passed by the learned additional chief judicial magistrate Kasar Silsor in NI case number 142 of 2021 under section 138 of the NI Act. It is to be noted here that by the impugned order dated 8/5/2026, the learned trial court has dismissed the complaint case on the ground that the petitioner herein remain absent on that day without any step. Mr. Rosid, learned counsel for the petitioner, submits that on 8/5/2026, the petitioner could not remain present before the learned trial court as he had filed one revision petition.
Well,
Yeah, you
yeah,
have filed a revision petition.
Criminal petition, my lord.
What is the number?
Number, my lord, I'm giving,
He had filed
criminal petition 597/25.
being criminal petition number 5/595
595.
of
Sorry,
2020.
597/2025.
597 of 2025, and as such, he could not remain present before the learned trial court on that day. And on such count, the impugned order is illegal and arbitrary, and therefore he has contended to interfere with the same. Pera, having heard the submission of Mr. Rosid, learned counsel for the petitioner, and also Mr. Porthakur, learned additional PP, this court is inclined to dispose of this petition by directing the petitioner to file an application before the learned trial court to restore the CR case now, NI case number 142 of 2021 to file, assigning the reason for which the petitioner could not remain present before the learned trial court, and on such petition being filed, the learned trial court shall consider the same in accordance with law. In terms of
I will file within 3 weeks, I'll file there. Within 3 weeks, I'll file
within
there.
3 weeks.
Right.
Within 3 weeks from today.
Item 15. May I please, Your Lordship? My lord, this criminal revision petition is preferred against the, my lord, judgment and order passed by the trial court, my lord, in a DB domestic violence case, my lord, and which is partially affirmed by the appellate court, my lord. Trial court judgment, my lord, starting from page 74, my lord.
Okay, let notice go at this stage.
Yes, my lord. Here in this case, my lord, apparently, my lord, this, my lord, guidelines of the Honorable Supreme Court provided in the, my lord, Sneha's case, my lord, was not followed, my lord.
You have not filed your affidavit
Yes, my lord.
indicating the assets and liabilities,
Yes, my lord.
is it?
Yes, my lord.
Are you sure?
Here, my lord, judgment is very much clear, my lord.
Heard, Mr. Barbhuya, learned counsel for the petitioner. In this petition under section 438/442 of the BNSS 2023, the petitioner has challenged the judgment and order dated 19/8/2025 passed in MISC domestic violence case number 207 of 2020. It is to be noted here that by impugned judgment and order dated so and so, the learned trial court has granted relief to the respondent on 4 counts. Number A, the petitioner shall petitioner was prohibited from committing any further domestic violence upon the respondent. Number B, the petitioner was directed to provide separate accommodation for the respondent. Number C, the petitioner was directed to pay monthly maintenance at the rate of rupees 12,000 to the respondent from the date of application, and number D, to pay compensation of a sum of rupees 1,50,000 within 15 equal installment. And also the judgment and order dated 8/7/2026 passed in criminal appeal number 49 of 2025, passed by the learned additional sessions as Kasar Silsor, whereby in criminal appeal number 49 of 2025, whereby the learned appellate court has prohibited the petitioner from committing any further domestic violence upon the respondent, and also directed to pay monthly maintenance at the rate of 12,000 to the respondent from the date of application. However, the learned appellate court has reduced the compensation from rupees 1,50,000 to rupees 1 lakh. However, the learned appellate court has granted no relief in respect of separate accommodation for the respondent. Peruse the petition and the documents placed on record, and also peruse the impugned judgment and order dated so and so passed by the learned trial court, and also the judgment and order dated so and so passed by the learned appellate court. Issue notice to the respondent returnable in 4 weeks. Step be taken by speed post and also by usual process within a week from today. Recessal call for the record from the learned trial court and also from the learned appellate court, and interim pair of the petitioner will be considered after receiving the on appearance of the respondent before this court and on receipt of record, not now.
Diploma.
May it please your lordship. I'm aggrieved by the author in this case, the lordship, at page 24. An amount of rupees 16 lakhs was taken as loan by me, your lordship, and an amount of rupees around 9 lakhs odd was defrauded from my bank. It is in different banks, your lordship. I had made an application for giving the money back, your lordship, but order dated 21/5/2026, your lordship, done it, subdivisional judicial magistrate did not allow it. The relevant part, your lordship, starts at page 25, if I may read.
Earlier one report was that report also today not received.
Not received.
Actually, admission not ahead of it. Na order to the I'm aggrieved by this order, your lordship, because there is already a clear finding at page 21, if your lordship may kindly peruse.
Let the report come.
Yes, sir.
This matter may come up for
Heard Mr. Devi, learned counsel for the petitioner, Mr. Barthakur, learned additional PP for the respondent. Mr. Borthakur, referring to the order dated 17/7/2026, submits that a report was called for from the concerned investigating officer, but the same has not yet been received. Accordingly, it is provided that Mr. Borthakur shall produce the report before this court on 14th August without fail.
I'm very grateful, Your Lordship.
In this case, my lord, this is 138 proceeding, my lord, here the case proceeded to the stage of defense witness. Now here, my lord, there were three accused, my lord. The company as well as the two directors, my lord. The signatory of the check was one. Both the directors are being prosecuted, my lord. So, my lord, at this stage, my lord, we wanted to call for the bank witness for proving the fact that the signature was of one director. On that, the steps could not be taken for some reasons, and in fact, on 27/8, 2024, the petition was
Where is
filed,
the impugned
steps were
order?
taken.
Where is the impugned order?
First order of lordship, that your lordship will find page 14. And on that day, steps were taken, but the 27/8, the petition was rejected. Only because of the fact that prior to filing the
You
defense,
have preferred one revision petition against the order
yes,
that was dismissed.
in fact, it was dismissed on the ground that earlier occasions, before filing of the DWs, I had taken number of adjournments. That is the ground.
You have taken?
Taken a number of adjournments. The only thing, the law is, only the signature of the check is can be prosecuted, Here is a case, where both the directors are being prosecuted as well as the company, That is not the law. And to bring that fact into this,
Who issued the check?
say one of the directors, the petitioner number one, no, two, three, petition number three, there are three petitioners. One is the company, petitioner 2 and 3, petitioner 2 had signed the check. 3 is not a signatory. 3 of them are being prosecuted. It's not them, but for in fact, steps could not be taken, because the aunt of the counsel of the petitioner, she expired. And on 27/8, steps were taken by the counsel, but it was rejected. At least a chance of fair trial should be given to me.
How many adjournments you have availed?
Adjournments prior to I'm not prior to giving DWs, there were a number of adjournments. That is true, In fact, that your lordship will find in
But
the
when,
revision of
after fixing the case for DW, you have not taken any.
Initially, we took time, Thereafter, we adduced evidence.
No, therefore, I am asking you how many adjournment after fixing the case for DW you have availed?
Your lordship. I'll take it. In fact, for around 4 or 5, That will lordship will find in page 21 of the revisional order, paragraph 7. It is not that it is only for because of the case is being delayed. In fact, the complaint had also taken time prior to that. But once the DWs it was continuing. There was lapses on part of the council, that is. Then in fact, if your lordship page 22 last part, the complaint has also taken time for cross examination, a number of times. It's not that it's a fallen part of the accused.
Heard Mr. R.D., learned counsel for the petitioner in this petition under section 528 of the BNSS 2023. The petitioner has challenged the order dated 27/8/2024 passed by the learned Judicial Magistrate First Class Sonitpur in NI case number 43 of 2023. It is to be noted here that by the impugned order dated so and so, the learned Judicial Magistrate First Class Sonitpur Tezpur in NI case number 43 of 2013 has closed the evidence of official witnesses of the petitioner and fixed the case for argument. Mr. D, learned counsel for the petitioners, submits that the petitioners are the accused in the NI case number 43 of 2013. And the said case was pending at the stage of evidence of the defense witnesses. Defense witnesses. But on 27/8/2024,
Evidence of two witnesses taken, Lord.
but on 27/8/2024, the petitioners herein could not produce the witnesses and their engaged counsel while prayed for another date for tendering evidence of the official witnesses, but on the objection being raised by the complainant side, the respondent herein, the learned trial court has rejected the pair and closed the defense evidence and fixed the case on 10/9/2024 for argument.
In fact,
At
today is the
what
day.
stage it is pending now?
Today is fixed for argument, otherwise.
Mr. D further submits that thereafter, the petitioner herein has preferred one revision petition before the learned additional district judge Tezpur, being revision petition number, criminal revision number 29 of 2024, but the said revision petition came to be dismissed on 16/12/2025 on the ground that the petitioner herein has availed several adjournments. Mr. D, learned counsel for the petitioner submits that not only the petitioners but the respondent herein as complainant also availed several adjournment, and due to the fault of the engaged counsel of the petitioners, the witnesses could not be produced on 27/8/2024, and that unless an opportunity is afforded to the petitioners to adduce the evidence of official witnesses, they will suffer serious prejudice and their right to fair trial will be violated. And accordingly, he has contended to allow the petition. Having heard the submission of Mr. D, learned counsel for the petitioner, this court has carefully gone for the impugned order dated 27/8/2025 passed by the learned trial court and also the judgment dated 16/12/2025 passed by the learned revisional court in criminal revision number 29 of 2024. it is well settled that right to fair trial is a fundamental right. In exercise of the said right, the petitioner herein are entitled to get fair opportunity to produce the to produce the evidence. To produce the witnesses in support of their defense, to examine the witnesses in support of their defense. And having considered above and also considering the facts and circumstances on the record, this court is inclined to dispose of this petition by setting aside the order dated 27/8/2024 and also the judgment dated 16/12/2025, and by directing the learned trial court to afford one last opportunity to the petitioners herein to adduce the evidence of the official witnesses. And thereafter, the trial court shall proceed to hear the argument and dispose of the case. The petitioner herein shall appear before the learned trial court on or before
Any date. Lordship may fix any date. Deeply obliged me.
May I, please, Your Lord?
this petition is for
My lord, for the quashing of a proceeding against me, my lord, against the petitioners, my lord, what has happened? My lord, the Director of Revenue Intelligence, my lord, has made a search, my lord, and basing on some seizure of rats and the loot, my lord. My lord, a proceeding had been instituted a long back in the year 2011, my lord. And after the, my lord, due procedure, and the Director of the Revenue Intelligence, my lord, had lodged a complaint before the learned Chief Judicial Magistrate, Milord Kamrup Metro, under Section 135 of the Customs Act, Milord. Now, Milord, since the date of this complaint had been lodged in the year 2016 as a case number, Milord, the first order, my lord, may be pleased to find, Lord, we have annexed. Lord, that, Milord, page number 58, Milord. Complainant is present, accused so and so are absent with step so and so. My lord, this is the subsequent order. The very first order has been, my lord, cognizance or, my lord, the other prayer which has been made. If my lord may be pleased to take up the prayer part which is at page 55 of my petition, what they DRI want, my lord, from in this proceeding. The complainant be admitted. Page 55, my lord. The prayer part. Charge be framed against all the accused persons and all the accused be furnished adequately as per law. Be punished. Process be issued to all of them for the purpose of prosecution. For that, witnesses mentioned in Annexure B examined. Now, my lord, the sole basis of this complaint against the present two petitioner is the statement made or the, my lord, deposition made before the, my lord, the intelligence, that is the DRI, and from the statement of the accused number one, my lord, our name had been, my lord, pronounced, that the material had been purchased from us. So, my lord, on the basis of that sole statement, my lord, we have been roped into, and now we are regularly, my lord, attending the trial, but the rest of the accused are not cooperating in the investigation, my lord. Altogether 10 accused are there.
no. Can it be a ground for quashing the proceeding?
My lord, because the long delay, my lord may kindly appreciate from the
No,
year.
why don't you file an application there for
The
splitting
third-
up your case?
My lord, we can, my lord, but the, my lord, the law, my lordship, with my limited knowledge, what I respectfully beg to submit, my lord, that the, when there is a long pendency of a criminal trial or the criminal prosecution is going on without any fruitful result, my lord, If
Mm.
my lord peruse the order sheet or call for the records also, it will transfer, my lord, that the no fruitful and even no attempt had been made by the DRI to issue summon or any other attempt, only the non-bailable warrant of arrest and arrest, my lord. Long
You can
tendency,
fi-
my lord.
you can file an application before the trial court for splitting up your case and to expedite the trial. Where is the bar?
Lord, the exped, my lord, we can, but my lord, if my lord
But
kindly
Mr.
appreciate,
Bhuya,
my
you
lord,
see,
My lord.
this petition you have filed
my lord,
is under section 528 of the
my
BNS.
lord,
This relief is extraordinary.
my lord.
So you have to the region, and when the alternative remedy is available,
My lord.
this power cannot be exercised by this court.
No, my lord, yes, my lord, in that case, my lord, my respectful submission before my lord is that, my lord, if my lord, when there is a long pendency of a criminal trial, my lord, I am not equipped with the judgment today, my lord. If I will make an attempt to satisfy my lord on this ground, just for a minute, if we cannot, my lord, then we will take the appropriate recourse. My lord may take up this issue on, my lord, Friday or.
Which judgment you are referring to?
My lord,
Here and Tule.
Tule and others are also there, my lord, recent judgments, my lord, and I will try, I will make an attempt, my lord, I will make an attempt.
Okay. Heard Mr. A.R. Bhuya, learned senior counsel, assisted by Mr.
Abdullah.
Learned counsel for the petitioner and Ms.
And Decca.
Learned counsel appearing on behalf of standing counsel,
DRI, my lord.
DRI. On the pair being made by Mr. Bhuya, learned counsel for the petitioner, this matter is then adjourned to be listed on
Next Tuesday, my lord. Mal.
Wednesday, so as to enable Mr. Bhuya to satisfy this court that on account of long pendency of this
Mal.
long pendency of the criminal case instituted before the learned trial court, the same can be quashed.
Quashed.
I have a prayer lordship. Trial court record may be called for this pending before Kamruk Metro lordship.
No, today only after hearing him,
Satisfied.
later on we will consider it.
Obliged. Deeply obliged.
May I please, your Lordship? No, as a limited prayer, Lordship, this petitioner failed to appear once, Lordship, in the last order, page 23 is the impugned order also. The very first day, Lordship, non-bailable warrant of arrest was issued respectively.
Heard Mr. Kolita, learned counsel for the petitioner. In this petition under Article 520, under Section 528 of the BNSS 2023, read with Article 227 of the Constitution of India, the petitioner has challenged the order dated 4/4/2026 and 4/7/2026, passed in NIA case number 4510 of 2019, whereby non-bailable warrant of arrest as well as proclamation and attachment has been issued against the present petitioner by the learned additional Chief Judicial Magistrate Kamruk and Gauhati. Mr. Kolita, learned counsel for the petitioner, submits that the petitioner is the accused in the NIA case number 4510 of 2019 and on 4/4/2026. Where is that order?
Lordship, the last page also of my petition, page 23.
On 4/4/2026. The learned trial court has issued non-bailable warrant of arrest against the present accused, the present petitioner, and fixed the matter on 4/7/2026. And on that day also, the learned trial court has directed to issue proclamation and attachment against the present petitioner. The learned counsel for the petitioner submits that on the very first day, the learned trial court has issued non-bailable warrant of arrest against the petitioner and thereafter has issued proclamation and attachment. And the required procedure for issuing the proclamation and attachment has not been followed, and as such, the impugned order is illegal and arbitrary, and therefore he is contended to set aside the impugned order and to allow the petitioner to participate in the trial of NI case number 4510 of 2019. Para. Having heard the submission of Mr. Kolita, learned counsel for the petitioner, this court has carefully gone through the petition and the documents placed on record and also perused the impugned order dated 4/4/2026 and by which the learned trial court has issued non-bailable warrant of arrest against the petitioner and also the order dated 4/7/2026 by which the learned trial court has issued proclamation and attachment against the present petitioner and fixed the case on 8/9/2026. Para. Having perused the order dated 4/4/2026 and 4/7/2026, this court is of the view that the required procedure for issuing non-bailable warrant of arrest and also for issuing proclamation and attachment has been followed by the learned trial court. And in that view of the matter, the impugned orders dated so and so stand set aside in quest. The petitioner herein is directed to appear before the learned trial court on or before
7 Lords. On or before 17. On or before 17 Lords.
And to file an application before the learned trial court for allowing him to remain on previous bail, for allowing him to go on bail, and on such petition being filed, the learned trial court shall consider the same in accordance with law. In terms of this petition stands disposed of on this motion states itself.
Deeply obliged.
Milord, in this case, Milord, a non-bailable warrant of arrest issued on 14/7/2026, Milord, page 39. And the next date is 31/8/2026 for appearance. Petition is reading, Milord.
So you go and appear before the learned trial court?
Yes, Milord. In the meantime, Milord, non-bailable warrant, Milord, maybe recalled.
Where is the impugned order?
Impugned order is page 39.
Mr. Sharma? Heard, Mr. A. M. Ahmed, learned counsel for the petitioner, and Mr. B. Sharma, learned additional PP for the state respondent. In this petition under order, under section 528 of BNSS 2023, read with article 227 of the Constitution Amendment, the petitioner has issued non-bailable warrant of arrest. The petitioner has challenged the order dated 14/7/2026 passed by the learned additional chief judicial magistrate Gwalpara in GR case number 59 of 2026, arising out of Krishna PS case number 10 of 2026 under section 64, which will make it 1, stroke 62, stroke 351, which will make it 2, which will make it 3, stroke 3, which will make it 5 of BNS, whereby the learned trial court has, at the very first instance, has issued non-bailable warrant of arrest against the petitioner. Why you could not appear despite receipt of summons?
Milord, in this case, a petitioner does not know about the warrant of arrest, Milord. Very day, on the very first day appear.
No, Mr. Ahmed, you have received the summon.
No, Milord. Summon not received.
Hmm?
On the very first day issue warrant.
Mr. Martin, Ahmed, learned counsel for the petitioner, submits that the petitioner has not received any summon. But in spite of the same, the learned trial court has issued non-bailable warrant of arrest against him. And that the petitioner is ready to face the trial. And therefore, he has contended to allow this petition by setting aside the impugned order dated 14/7/2026. Mr. Sharma, any submission?
My submission is ready to appear before the court and
The learned additional PP.
and court will consider.
Mr. B. Sharma also submits that the petitioner may be directed to appear before the learned trial court and to apply for regular bail. Then in the event of filing such an application, the learned trial court may be directed to consider the same in accordance with law. Accordingly, taking note of the submission of learned counsel for both the parties, this court is inclined to dispose of this petition by directing the petitioner herein to appear before the learned trial court on
Milord, next date 31st/8, Milord. Next date is 31st/8.
on 31/8/2026 and to apply for regular bail, and in the event of filing such an application, the learned trial court shall consider the same in accordance with law. Till then, non-bailable warrant of arrest issued against the present petitioner shall be kept in abeyance.
Obliged.
In terms of this petition is disposed of at this motion is itself.
May I please your lord? Well, the matter relates to negotiation with Instrument Act. My lord, what happened? I take your lordship. Page 92, my lord. On 16/8/24, the case was, my lord, actually filed.
No, that's
As
all
there
right.
was no state.
Why you could not appear before the court on 5/4/2018, 15/6/2018,
No, like case was filed, my lord.
and
From
19/2/2020?
29 to 22, case was filed, my lord. After 4 years, case was revived by the court.
Hmm.
By the court. But what happened? Out of 9,50,000, I have paid 5,15,000, 65,000. And my lord, because of the death of my father, I have left for Bihar. Now I was working at business at Bongaigaon, so I have stopped the business, my lord. I could not come from, because whole responsibility of the family is shrouded of me. Now, my lord, that's why summons and PNA was issued. It was never served, but it has gone to my rented house. So they have informed me that there is a PNA, and then now I have come from Bongaigaon. So I want to settle the matter. One installment I want to pay. And out of 9,50,000, 5,65,000, I have already paid. I have annexed the documents. So, my lord, if you want to give me an opportunity, I hope and trust that it will be settled, my lord. If I could pay 5,65,000.
Okay. Mr. S. Business Learned Counsel for the petitioner. S.A. Business Learned Counsel for the petitioner and Mr. Sarma Learned Additional PP for the respondent number 1. In this petition under section 528 of the BNSS 2023, the petitioner has challenged the order dated 5/4/2018, 15/6/2018, and 29/2/2020, and all subsequent orders by which the learned trial court has issued warrant of arrest, non-bailable warrant of arrest, and proclamation and attachment against the present petitioner. As the business learned counsel for the petitioner submits that the petitioner is an accused in NICR case number 12 of 2016, pending before the Court of Learned Additional Judicial Magistrate, Boygaon. And for quite some time, the case was filed, and thereafter the present petitioner left for Bihar. And after 4 years, the case was revived, and thereafter, by impugn orders and subsequent orders, warrant of arrest or non-bailable warrant of arrest, and proclamation and attachment were issued against the petitioner. But the petitioner is ready to face trial, and he will pay the remaining stake amount to the respondent hearing, respondent number 2 hearing, and he may be given a chance to participate in the aforementioned proceeding of NICR case number 12 of 2016.
Madam, in this case, although complaint case, madam, he was absent for a long time, madam. After a long period, madam, thereafter, court was pleased to issue, madam, non-bailable warrant, thereafter, TNA, madam.
That I admit, because I was not in Bongaigaon, I could be. And the complaint was also silent for 4 years.
Mr. B. Sharma, learned additional PP, has opposed the petition on the ground that for quite long time the petitioner remained absent before the learned trial court. Trial. However, considering the submission of learned counsel for the petitioner and also considering the facts and circumstances on the record, especially the submission of Mr. Research that the petitioner is ready to participate in the trial, and also he is ready to make payment of the remaining stake amount, as he has already paid.
21st August is the date.
What amount you have already
I paid? I'll show. Kindly. 1 minute, minute. 5,65,000 I paid, madam.
5,60,000?
5,15,000 page, page 8, minute, para 12. 5,50,000, 15,000 out of 9,50,000.
Out of 9,50,000, and he will pay the remaining amount.
5,15,000.
And therefore, he has contended to
rest of the amount I will pay by installment method.
Participate in the proceeding. Better. Having heard the submission of learned counsel for both the parties, and also considering the facts and circumstances on the record, this court is inclined to dispose of this petition, that this motion is itself, by directing the petitioner to appear before the learned trial court and to apply for regular bail. And on such petition being filed, the learned trial court shall consider the same in accordance with law. On or before coming?
19 August.
19 August. When the next date is fixed?
21 August.
21 August. 21 August. And on such petition being filed, the learned trial court shall consider the same in accordance with law. Till then, the non-bailable warrant of arrest and the proclamation and attachment issued against the present petitioner shall be kept in abeyance.
Disposal.
24.
Hello, Tyler.
Yes, Mr. Ahmed.
My lord, a total 404 acres of land were allotted to the petitioner and 200 other family members. Subsequently, those landholders disappeared, and thereafter they again appeared and were in position. We cultivating the land, but sometimes in the 2024, the opposite parties here, they forcefully come to the land, and then there is a quarrel, and both the parties lost their behalf. A case has been registered against both of the parties. Then I filed a petition for possession and attachment of the land because there is a serious breach of peace and public tranquility. And again, in Lordship can see page 29 and set 3, the learned magistrate, after producing the police report, attached the land. The Lordship can see the second paragraph, my lord. However, certainly on 1/12/2024, at about the opposite parties along with so.
Okay, Mr. Ahmed,
My lord.
let notice go at this. Is this?
No, yes, sir. Notice go and in the meantime, invoke orders issued by. Because there is a attachment order, in violation of attachment order, they come to the land and police reported that both the parties were restrained.
Mr. Ahmed, learned counsel for the petitioner. In this petition under section 558 of the BNSS 2023, the petitioner has prayed for quashing and set aside the impugned judgment dated 6/7/2026 passed by the learned additional session Judge Kamrup Amingaon in criminal revision number 17/2025. It is to be noted here that by the impugned order dated so and so, the learned additional session Judge Kamrup Amingaon has upheld the order dated 21st of August 2025 passed by the Executive Magistrate Kamrup Amingaon. Mr. Ahmed, learned counsel for the petitioner, submits that on the basis of one complaint lodged by the present petitioner, the
Case number
what
9.
was the
M,
parcel of land?
my lord,
What was the parcel of land seized or attached?
404 acres total.
The disputed property involving 400 and
My lord,
404
4 acres.
acres of land was attached by the executive engineer.
Executive magistrate.
No, sorry, executive magistrate
By the order dated
in
6/1/2025. Page
in case
29.
number
Page 29.
what is the case number?
Case number, my lord, 9M/2025.
In case number 9M/2025 under section 164
165
BNSS. And what happened thereafter?
Thereafter, my lord, without hearing the parties, police reported that both the parties were restrained, order has been executed. In the meantime, both the second parties entered the land, forcefully entered the land. We filed a petition for violation of the court order. That has been not considered, and the learned magistrate, without hearing the parties, passed final order
And
directed to hand over the land to the
existence of the
second party.
attachment order, the opposite parties entered into the suit land. And thereafter, the petitioner herein, after they are entering into the suit property, what happened?
In violation of the court order,
Yes,
then police, after seeing the police report, that now they are in no dispute. On the basis of that report, my
And
lord, page
thereafter,
43.
on the basis
Order has
of
been
the
vacated
police
and
report, the attachment order was withdrawn.
vacated and directed to hand,
Vacated.
yes, and directed to hand over the land to the opposite parties.
And directed to hand over
Without
the
hearing,
land
without
to the
taking any
opposite
evidence.
party. And though the
By order dated
petitioner
21/8/2025.
has filed the revision petition against the order dated 6/1/2025.
Revision filed against the order dated 21/8/2025.
Page-
21-8,
Page 43,
21-8,
8/2025.
25. But the same came to be dismissed.
By
And
this
that the
order,
impugned
attachment
orders
order
are
vacated and
illegal
directed
and
to
therefore
hand over the land.
he submits that pending disposal of the petition, the impugned orders, judgment and orders passed by the learned executive magistrate and also by the learned additional session judge Kamrup Amingao may be stayed. The submission of Mr. Ahmed received due consideration of this court. The impugned orders dated so and so were carefully gone into. And taking note of the submission of Mr. Ahmed, learned counsel for the petitioner, the impugned orders dated so and so
Good order.
passed by the learned executive magistrate Kamrup Amingao and also by the learned additional session judge Kamrup Amingao in criminal revision number 17 of 2025 stands state. Issue notice to the respondents, returnable in 4 weeks. Step be taken by speed post and also by usual process within a week from today. Call for the scan copy of the record from the courts below, list the matter after 4 weeks.
Lovely.
Number 44, other matter.
May please your lordship, but in this case, my lord, pursuant to your lordship order, my lord, dated 3/6/26, my lord, the insurance company has already deposited the amount, my lord, before the registry of this honorable court, my lord. That you lordship will find that page 24 of our additional affidavit, my lord. They have enclosed, my lord, along with this photocopy of the check, my lord. They have deposited 18,90,511, my lord, inclusive of interest.
No, it amount to when did you file the additional affidavit?
That is in support of this, the justice service, my lord.
Okay, justice service. When did you file?
That was portrayed
37.
37, 2026, my lord. On last, my lord.
The amount was deposited before the registry of
Registry of
court.
this honorable court, my lord.
When?
That was deposited, my lord, on 17/6, my lord.
17/6.
That is the letter, my lord. It addressed to the register of this honorable court, my lord.
Okay, we'll take it up at 2 o'clock. In the meantime, we will call for the additional
I
affidavit.
can publish the extra copy, my lord. I am holding, my lord.
After some time, after some time.
Let me at 2, my lord.
Okay, 2 at 2. Let the affidavit come.
45 and 46.
For 45 and 46, your lordship will need to file our affidavit in opposition, your lordship. Your lordship kindly grant us 3 weeks time to file this.
Since when this matter is pending?
Yes, it's pending, my lord. They are to file the affidavit, but they are not filing. Affidavit mainly, my lord, with regard to one particular issue that as to why the petitioners has been discriminated, but which has come to our knowledge
No,
on.
that's all right. But the question is, without their affidavit, can we hear this matter?
Their affidavit with that.
So it was came on orders column.
With that information will be required, my lord. That will be required.
Let them file their affidavit
Yes.
then. Heard Mr. Purkaso, learned counsel for the petitioner. And Ms. P. Das, learned standing counsel for the secondary education department. Ms. Das submits that she may be granted some time to file the affidavit. Pair allowed, list the matter on.
3 weeks after 3 weeks.
If it was after 2 weeks, madam.
Okay, after 2 weeks, list the matter.
Your lordship.
After 19 August.
Only before.
19th of August.
Item 47.
Lord, in this case, steps were taken in respect of the respondent, my lord. There is sole respondent, my lord. But the office note says that, my lord, neither the ID card nor the service report has come, my lord. So my humble prayer would be, my lord, that warrant has been issued against me, my lord, by the trial court, my lord. Because this matter pertains to, my lord, non-payment of, my lord, maintenance amount, my lord. So I approach the sessions court, my lord, as per the direction of this honorable court. There was a delay, my lord. That delay petition has been dismissed, my lord. So against that I have come, my lord. I have taken the steps against the respondent, my lord. So at this stage, my lord.
But unless the notice is served, what can
Therefore,
this
my lord,
court do?
so far my instruction is concerned that notice has been delivered to her. So I will, my lord, inquire from the tracking consent report, my lord. So after 10 days, the matter may kindly be.
After 10 days.
My lord.
Okay. Heard, Mr.
A. Ali.
A. Ali, learned counsel for the petitioner. Office note dated
37/2026.
38/7/2026 indicates that neither ID card nor answer notice returned issued to the sole respondent returned till date. Mr. Ali submits that the matter may be listed after 10 days.
My lord, maybe after 1 week, my lord, because
After 1 week, so as to enable him to track the consignment in the departmental website. Where allowed, recessor list the matter on 14th.
I'm obliged.
48.
Kindly pass over the matter for the time being. Mr. R. Ali, he is appearing only in court number 8.
49.
Well, kindly take matter at 2 p.m. ma'am. At 2 p.m. ma'am.
Advocate. Notice survey one. What happened?
Kindly take matter at 2 p.m. ma'am.
Why?
That senior is coming.
No, you see, we have some other matters also. We are not sitting with your matter only.
Madam, kindly.
Whether notice is served here. The service report received.
Service report not received.
Sir.
When you have deposited the notice in the office of the public prosecutor.
That day, steps.
That day.
Well, on the day of 29th, my lord, as
Sure.
29.
29.
Mr. Locker, when it was sent to the jurisdictional, yes?
I will take instructions that I explained.
When?
PP officer December.
Yes.
That I have the instruction I have not, that I will take instructions.
Mr. Locker, you see, the matter is fixed today. So you have to present here with all the required information.
Would say. Yes.
Can I? Okay. One tracking, they got it, my lord. Although in the office note, it is not there, my lord.
It has to start from the office, our office, also about the police, OC concern also.
Can I pray one thing, my lord? Since today is a date fixed and tomorrow also date fixed, my lord. Can I make us be appointed and, my lord, tomorrow, if your lordship hears it, my lord, for final disposal, my lord. As your lordship pleases,
No, unless notice is served upon the respondent number 2,
my lord.
how can we appoint amicus?
Considering the urgency, because my lord,
Urgency.
date will
It may
elapsed.
be urgent to you, but it may not be urgent to the other side.
Otherwise, the
What
petition
is
would
the
be.
purpose of
Yes.
issuing notice to the respondent number 2?
The only thing, my lord, their concern, they has to be, they are to be
We,
heard, my lord.
court has to balance the
Yes,
interests of
yes,
both the parties,
definitely. They have
not
to be
only
heard.
you.
Their version, my lord, their stand, they have to be.
Okay, you obtain instruction when the notice was sent and whether it is served. After some time, let him obtain instruction.
Then at 2 p.m., my lord, 2 p.m.
2 p.m. Okay, at 2 p.m.
Obliged.
May it please your lordship. Lordship, on the last occasion, lordship, CD was available, but the post-mortem report was not there. My lord, I am behind the bar for last 66 days, my lord. I am not the, my lord, named FIR, my name is not named in the FIR, my lord. I was subsequently arrested on the basis of, my lord, the statement of co-accused, my lord, who were earlier arrested, my lord.
Report also received, my lord.
Yes.
PM report was other from the PM report, my lord. Opinion, my lord, regarding the exact cause of death could not be ascertained and special preserved. So from the PM report, my cause of death, my lord, could not be ascertained.
No, is there any material in the case diary against him?
Initially, my lord, that this was found, my lord, that in a vehicle thereafter, my lord, he was shifted to the hospital and he declared dead. And my lord, allegation is that some, my lord, that those, my lord, drugs were purchased from the present petitioner, my lord.
My lord, regarding that,
His statement is that he along with the, my lord, deceased who consumed drugs in that vehicle, my lord, those drugs were purchased from the present petitioner.
my lord,
That is the. Just a minute.
my lord, regarding that section, my lord, that NDPS, my lord, section 27.
One other accused, my lord, one Biswajit Gogoi, my lord, other person stated that before putting, along with the deceased, my lord, in the vehicle that Biswajit Gogoi was also there, according to the some of the, my lord, said that thereafter Biswajit Gogoi was also arrested and from the statement of the Biswajit Gogoi, he said those drugs were purchased from the present petitioner. কিন্তু আমাৰ পলাশনি মাধৱপুৰৰ পৰা 1000 টকাৰ ড্ৰাগছ কিনি আনি নেশ্যনেল হাইৱে 37 ষ্টৰেঞ্চৰ ওচৰত ৰাস্তাৰ কাষত মোৰ বগা ৰঙৰ গাড়ীখন ৰখাই তাতে ড্ৰাগছ খাই আছিল ড্ৰাগছৰ লগত আমি বিয়েৰ খাইছিলো পিছত
For how long you are behind the bar?
66 days, my lord.
66.
66 days, my lord. And regarding that section, my lord, that NDPS, my lord, that is a
That is
bailable,
bailable.
bailable one. And I am no, and I was also, my lord, taken into custody for 1 day, my lord, by police custody, and nothing was recovered from me as well as from my residence.
Okay, Mr. Bortakur, what is the case diary will say?
Yes.
Okay.
My
We'll
lord,
pass
one
the order.
more submission I just want to make, my lord. During this recent flood, my lord, I am from the Olohoni village, my lord, of Shivsagar district, my lord. My
We'll say.
was submerged, my lord, my home and all.
29.
May I please your lordship? Lordship, NDPS is there, 21B lordship.
20?
FIR 21B lordship.
21B.
42
You were
days
behind the
before-
bar for how many days?
42 days lordship. Arrested on 23/6/2026. FIR is at page number 16 lordship.
Yes, yes. In this case, reading out the statement, Karthik submitted.
Search.
Lordship, there is no direct allegation against me, lordship, not recovered from me also, recovered from one.
Oh,
And the-
what is the quantum of contraband substance? What is the FIR?
Page number 16 lordship.
$12.03 gram.
12 point
03 gram.
heroin.
Yes, sir.
recovered from one Liaquat Ali Lordship on the basis of co-accused statement Lordship. I was arrested Lordship.
Nothing has been recovered from your possession.
Lordship. As per FIR Lordship, second para Lordship.
Hmm.
After the special manager Hannan Ali Ahmed has arrived after collecting the authority letter from additional SP Samiran Boisho in my name, accordingly I along with the police team proceeded towards Bhogarandha village, the departmental vehicle bearing such and such along with investigation kit, digital waiting machine, etc. by Borpeta, such and such. After arrival of the Bhogarandha village, the source of person showed us the house of Liaquat Ali, son of such and such. Lordship, Liaquat Ali. I am Mohibul Islam, Lordship.
Where is the forwarding report?
Forwarding Lordship 18, page number 18. Co-accused stated my name, Lordship, that's why I was arrested, Lordship.
Mr. Borthakur, you see, since Sarset is submitted, the question of hampering investigation or the tampering witnesses, it does not arise from this instance. And from the position of the accused, nothing has been recovered.
Yes.
He has been arrested on the basis of statement of co-accused.
Confessed that he both the suspected even Mohibul Islam.
Okay, heard miss, your name please?
P. Kolita, Lordship.
P. Kolita, learned counsel for the accused, and Mr. Borthakur, learned additional PP for the state respondent. This application under section 483 of the BNSS 2023 is prepared by accused Mohibul Islam, who has been languishing in jail as in connection with Borpeta PS case number 173 of 2026 under section 21B, struck 25 of the NDPS Act. Since 23rd 6 2026. Is to be noted here that above noted case has been registered on the basis of one FIR lodged by SI Lisa Taye on 21st of May 2026. The allegation in the FIR, the essence of allegation in the FIR dated so and so is that one Liaquat Ali is found in possession of 12.03 grams of heroin on what is the date? On 28/5/2026. The learned counsel for the accused submits that nothing has been recovered from the possession of the present accused, and he has been arrested only on the strength of the statement of co-accused, and he was arrested on 23rd 6 2026, and that after completion of investigation, charge has been submitted and the accused is ready to face trial, and therefore it is contended to allow the application. Mr. Borthakur, learned additional PP, submits that after completion of investigation, the IO has laid charge against the present accused. Being charge number?
193 of 26.
193 of 2026. Under section 21B and 25.
Yes, sir.
25. It appears that the quantum of contraband substance allegedly recovered from the possession of accused Liaquat Ali is of 12.7 grams. And it also appears that on the basis of statement of co-accused, the present accused has been arrested and nothing has been recovered from his possession. In the meantime, the IO has completed investigation and submitted charge sheet. Submitted charge being charge sheet numbers so and so, so and so. Now the trial will start and the accused has to prepare his defense. And since charge sheet is submitted, the question of hampering investigation or tampering witnesses does not arise. And under such circumstances, this court is inclined to allow this petition. It is provided that on furnishing a bond of rupees 25,000 with one surety of like amount to the satisfaction of the learned special judge NDPS Borpeta, the accused be enlarged on bail. None appears for the accused on call, leaves the matter after a week. In the event of subsequent non-representation of the accused, appropriate order shall follow.
Numbers, 52.
The argument was concluded on the last occasion. It was from our both sides.
This petition dismissed.
Matolai.
53.
Mr. Singh, there are several decisions of Supreme Court that you have to satisfy the twin requirement of Section 37. The decision of Bombay High Court will not help you. And since you have
I am applying the recent decision of the apex court. Milord, the contravene just. From paragraph number 2, Milord. The contravene involved in the present case is 22.950 kgs of ganja. The learned counsel appearing for the petitioner would submit that her client is in judicial custody past more than 1 year. In my case, it is almost 2 years, Milord.
no, Mr. Singh, you see.
We are informed that although, Milord, charge has been
No,
framed.
Mr. Singh, you see, here the Section 37 is not discussed.
Yes.
This will not help you. Your petition dismissed.
No, Milord, this is the section
Sorry,
37
next
matter,
item.
Milord.
33.
Obliged.
But the other side is NCB, Malad.
NCB.
NCB.
Mr. Dev Sodari was there earlier.
Right.
Okay.
It's the pre-arrest bail, Malad. Although it's a Malad relates to Malad NDPS case, Malad.
But whether in NDPS case, anticipatory bail application is maintainable.
Malad, to my understanding, there is no bar, Malad.
Hmm.
Here, Malad, only one note. The case, Malad, ultimately charge sheet was laid, Malad, where, Malad, my name is not there. And neither I have been shown as an absconder, Malad. But a notice was issued that your lordship will find at page 22, Malad, under 67, to appear before the.
Okay, let Mr. Sodari
Right.
come.
Malad.
In his presence, we will consider your submission.
Then can it be, Malad, day after tomorrow, Malad?
Why? If you have not been solicited,
Malad.
then
Then, Malad, at 2
at
o'clock.
2 p.m.
124. The dead body was found in the river. The dead body was found in the
river, that's standing, and there was the injuries on his neck. So it is a clear case of murder, but.
Where is the CD?
CD is similar.
Available.
CD is similar.
Okay. Mr. Mahmood, you want to file objection here?
Yes, my lord, definitely, but we have not got the copy, that is why, my lord.
What copy? Copy of the
Yeah,
petition?
bail petitions copy to be made.
Furnish a copy to him.
I will do.
Heard Mr. Sharma, learned counsel for the accused persons, and Mr. B. Sharma, learned additional PP for the state respondent, and Mr. Mahmood, learned counsel for the informant appearing. You have filed your Ukalanama?
Yes.
When? Mahmood, okay, all right. Appearing on behalf of the informant. And Mr. Mahmood submits that he may be granted some time to file objection. They are allowed to list the matter on
48,
yes.
Today.
14.8. 14.8. Till then CDB retained and the accused person shall remain on the interim order passed earlier shall continue till then.
Highly obliged.
May I plead the lawsuit myself? 36, 37, 38, same FIR. Forest.
Yeah. After some time, he will inform the council.
637. 39.
May I please, Your Lordship? Pre-arrest bail application, my lord. Offense under section 318(4), my lord, deals with cheating, my lord. 319(2), cheating by personation. 316(2), criminal breach of trust. And 3(5), my lord, common intention. Subsequently added, my lord, section 14, Assam Gaming and Betting Act. And let's see the, my lord, page 11, my lord, 11 part is, my lord, page 14, FIR, my lord. Page 14, my lord. May I read? I hereby lodge this FIR to state that based on reliable sources information, it came to notice that one Masood Jindul Ahmed, son of Mizanur Rahman, resident of Bongugi PS Kolgasia, district Borpeta, Assam, has allegedly been operating a nexus involved in cybercrime activities in around Kolgasia area along with his associates. This Masood Jindul Ahmed, who is the main accused of this case, who is already released on regular bail, my lord. Then, my lord, during investigation from the house of Masood Jindul Ahmed, numbers of articles says police investigation officer, my lord. Then, my lord, from the mobile shop of Masood Jindul Ahmed, a number of brand new mobile also seized, my lord. Kindly see my part, my lord, page 17. This is the relevant part for me, my lord, page 17. Thereafter, the police team proceeded to the residence of the co-accused, namely Raju Ahmed, present petitioner. However, prior to arrival of the police team, the accused person managed to flee from the spot. Subsequently, search was conducted at said premises, during which the following suspected incriminating articles were recovered and seized in presence of witnesses, my lord. Now, my lord, kindly see
So
the
these
list
are
of,
all mobile phones seized from your possession.
my lord.
From your possession.
My lord.
There's a
Page 17 onwards, all are recovered from my possession. Yes, my lord. But I'd like
altogether 45 mobile phone
yes,
have been seized from your possession.
45 mobile phone along with, my lord, some. Yes, total serial number is there from 1 to 88 total. These 88 articles are belongs to me, and out of which, my lord, I'd like to go through the actually contents of the seizure, actually what seized from my possession, my lord, for a moment. UPI scanner, 1, 2, 3 are the UPI scanner. serial number 4 to 45. These are the brand new mobile phone, my lord. I am also the mobile shop owner, my lord. I have annexed my trade license, my lord. These are the brand new mobile which seized, my lord. And 46 to, my lord, 65. These are the some ATM card and credit card, which are belongs to, my lord. 46 real number. My name is there, Raju Ahmed. 7 Raju Ahmed. 9 Raju Ahmed. 50 Raju Ahmed. 51 Raju Ahmed. All are belongs to my name, and some are in my family, like my younger brother and father, my wife, like the other are also belongs to my family, my lord. And kindly see the page 20, my lord, FIR. Here is 4 accused persons' name is there, my lord. Earlier on, Masood Jinnul Ahmed, who is name recorded in the first page of the FIR. Here is another 5. Raju Ahmed, present petitioner, Saminul Islam, who is already got, my lord, pre-arrest bail by the coordinated bench of this honorable court. Mahabur Rahman, other accused, Sanidul Islam. Sanidul Islam also pre-arrest bail, my lord. Sorry, Saminul and Sanidul both are same petition, and during pendency of that petition, Saminul arrested, so AB petition became infectious against him.
Let this petition be considered by the court in advance.
My lord, that order may be passed, my lord. That bench was, my lord.
That bench is not available. Otherwise, the main accused person, that is Masood Ziaul Ahmed Lordship, he has implicated this person. All these are there in excess Lordship. All these persons are doing what they are doing. They used to purchase some old phones, and they used to sell it. And at the same time, they also provide SIM cards for online gambling Lordship, online betting that they also used to provide. And therefore, they used to collect money from the out of the state also, not from the Assam only.
Okay, you do one thing. You mark the relevant pages of the case there, you will see. You will pass the order.
My lord,
After going through the case there.
yes, my lord. That is, my lord, subject to lordship permission. I'd like to submit my case if your lordship allow me for a moment, my lord. In support of my case, my lord, what I am placing, my lord. Actually, this FIR lodged by the police personnel, my lord, and allegation cheating and criminal breach of trust, my lord. As per, my lord, essential ingredients of these two sections, my lord, there must be some individual victim. And as per my submission, my lord, there is no individual victim that will reveal from the CD, my lord, whether victim they or not. But my submission, there is no individual victim, my lord. Second part, my lord. These two sections, since essential ingredients are not satisfied, so these two sections not attracted against the petitioner, my lord. Now, my lord, allegation of, my lord, cyber fraud. Cyber, my lord, yeah, usually it is committed through electronic modes, my lord, cyber. So IT Act must be there, but IT Act is totally silent. There is no IT sections of provisions of IT Act, my lord. And 14, there, my lord, we are not admitting, but assuming, my lord, there may be case of section 14 Assam Gaming Betting Act, my lord, which maximum punishment is 3 years, my lord. And, my lord, co-accused, my lord, AB, anticipatory bail, my lord, granted by this coordinated bench office. And main accused Masood Jinnul Ahmed, who is also entitled to regular bail. So, my lord, under this situation, my lord, since, my lord, whatever may be disputed articles, all are seized from already seized, and they are under the police custody at present, my lord. So, and it's not a case of huge, my lord, financial fraud or scam like that, my lord. Some secret information received by the police, and according to that information, my lord, sudden visited and some articles are required, which are, my lord, I have already stated. So, my lord, at this stage, my lord, since everything are recovered, co-accused are granted bail, and other of some arrested, police sufficient got the opportunity to properly investigate, inquire the case, my lord. At this stage, my lord, my submission, my lord, custody not required, my lord. And the last submission, my lord, 40 on a CRPC, my lord, all are maximum punishment is 7 years. 40 on a CRPC police can issue to me, my lord. That provision is not complied, my lord. That is my last submission, my lord. And after perusal, my lord, kindly observe one thing, whether any individual victim is there or not. There may be a statement in the CD, yes.
No.
Something is there.
What is to be observed, what is not to be observed, it is the discretion of the court.
My lord, my submission, my lord, is subject to lawsuit correction, my lord.
Okay. Law court, please hand over the case diary to the court master. Yes, next.
Item 40.
I'm deeply obliged. My lord, I would like to place co-accused bail order, which are already released, my lord.
Well, on last occasion, your lordship directed my learned friend.
Thakur.
41.
Same prayer, man.
42.
May it please, Your Lordship. Lordship, this is the pre-arrest bail application, Your Lordship.
That's okay.
Lordship will find the FIR at page 16, Your Lordship. May I read, Your Lordship?
Okay, there is. So is there any material?
My lord, material says there, my lord, here, I will also submitted on petition, my lord. With the driver and handyman, my lord, both the person, my lord.
Petitioner number 1 is the driver and petitioner number 2 is the helper, Your Lordship. And the place of occurrence, the owner of the residence where the entire incident has happened, Your Lordship, they were initially arrested. 2 persons were initially arrested. They were in the custody, Your Lordship. And to my information, they have also been granted bail, Your Lordship.
They are bail, my lord, but they are apprehending when the police came to the place of occurrence, my lord, they have stayed away, my lord, from that spot. And they are the driver and handyman, they have taken the vehicle to the accused person Bipin Rasko and Epo Rasko in their house, my lord.
They are the
And
own,
they are, my lord, oil were
they are the actual persons who were
my
who were involved in that incident, and they are the owner of the house, the residence, where allegedly our truck was parked and was seized there from, Your Lordship. And Lordship, one interesting fact, Your Lordship, one report we have annexed in our petition, Your Lordship, that
Page number? Page number.
page number, Your Lordship, that report, Your Lordship will find that page 24 is the copy that we have annexed, and page 23 is the type copy. Lordship, that truck which was initially seized was also released, Your Lordship. Thereafter, this report had come into light, Your Lordship.
Okay.
That
Yes, Mr. Sharma,
my lord.
whether their custodial interrogation will be required.
yes, Your Lordship.
My lord.
This present petitioners.
My lord, here, I also pay objection filed, my lord. Here it says that, my lord, to another truth, my lord. Here custody also is required, my lord, for
Oh, another truth, you can definitely you can interrogate them.
my lord.
If they are granted the PRS bail, they will appear before you.
Lordship, as per the report, there is no difference in the quantity from the seized vehicle, Your Lordship. After the seizure was done, Your Lordship, and the Jimma was granted to the owner, Your Lordship, of the vehicle. Thereafter, the truck was taken to the oil, Your Lordship, and this report was prepared by them, Your Lordship, where apparently there is no change in the quantity and volume of the petroleum product inside, Your Lordship, the tanker, Your Lordship. There was
We'll see.
My lord.
deeply obliged.
Okay. Very simple.
May I please, your lordship? In the morning, my brother was pleased to intimate that the CD is here. And lordship will kindly find that my name is not figuring in the FIR. That is in page 23, lordship. Thereafter, what happened, lordship? One notice has been served upon me under 91 CRPC that lordship will find in page number 24. Actually, in my name, some works were allotted. And these works were executed by 1/3 person who happens to be one of my associate. Now, while these works were being executed by us, lordship, some documents we have already submitted to the Assam Fisheries Development Corporation. Now, notice was issued. In that notice, some documents were short for from me. Those documents were not available with me. So I was at that time, I was sick, lordship. I submitted one letter that your lordship will find in page number 26. After I submitted a letter in page number 26 on my medical ground, one fine morning, the IO visited my residence and he forced me to come along with him to Gauhati, and then my statement was recorded. My statement under 164 was recorded very interestingly. And even after my statement was recorded under 164, I cooperated fully. Thereafter also, a notice is again issued against me because on the same ground that I am unable to produce those documents. And now I'm anticipating, because I'm unable to produce those documents, page number 34, annexure number 6, Lordship, may kindly have a look, Lordship. 3, 4, and 5. Admittedly, these documents are not with me. So therefore, I am anticipating, because some officer has already been arrested. And therefore, I am anticipating strongly that I may also be arrested. I don't know what is in the case diary against me. But otherwise, these works were all executed. And the second work that was executed by using the local people out there. And the local people, they have not issued me the GST certificates, for which these GST documents could not be given. That part I have mentioned in para 6, page 5, Lordship. There specifically everything is mentioned in my petition.
Okay.
Page number 5.
This case against some of the officers of the Assam Financial Development Corporation Limited for Mr. Property. There are various allegations against all those officers. And cases registered under prevention of corruption. Also, regarding the present petitioner, I talked to the IO also. Why he has approached for anticipatory bail, my lord. I tried to find out, then from his instruction for the record also I have found. Actually, in fact, he was cited as a witness, my lord. His 164 statement was also recorded before the trial court. The Honorable Special Assam Gauhati Order dated 22/7/26 was pleased to allow the prayer and directed the other side to produce the witness before the learned citizen Kamrup Metro Gauhati at the same day. Kamrup Metro was directed to record the statement and thereafter his statement, 183 statement also recorded before the also recorded.
Thereafter, they are issuing me notice
He was the
under 91.
The enterprise, but that is a farm, probably at that point of time, some of the works might have adopted and those money released to in the name.
No, Mr. Portagar, what is the instruction of the IO?
Because he cited as also his custodial interaction in this one, his statement 183 also recorded, and he was in fact why he has approached
I have
No, his contention is that he has received a notice under section 91.
91.
Yes, for producing some documents, and earlier.
91 section 91 notice may be given to any person, not only to
Now-
the accused.
now, Lordship,
It may be to the witnesses also.
Those documents are not with me. And
No,
that
that
is why
does
I'm
not
anticipating.
create any apprehension in your mind that you will be arrested.
Yes, Lordship, because
That-
already some of the engineers, those were related with this work, they were
Okay.
arrested.
Okay, we'll pass the order. Hand over the case there.
Yes, sir.
31 and 32. Diploma.
No, I am appearing in item number 31. Learned esteemed senior colleague is appearing in 32, my lord. Same case, my lord. We are in custody for the last 69 days, my lord. Case diary was called for, my lord. Case diary has come. And my lord, the principal accused have already been enlarged on bail, my lord, after serving 57 days. In
Oh, how long you were behind the bar?
My lord, 69 days.
60?
69 days, my lord.
And what is the punishment prescribed for the offenses?
My lord, 409 is there, so 90
Life
days.
imprisonment.
Life imprisonment, 409 is there, my lord.
Okay.
So,
So,
lord, will kindly see, my lord.
Is there any material in the case diary?
Yes, but otherwise, all other accused persons were allowed on bail by the citizen. After custody instructs,
May not be necessary. Okay. Heard Mr. Nawaz, learned counsel for the accused, and also heard Mr. Bortakur, learned additional PP for the state respondent. This application under section 483 of the BNSS 2023 is preferred by accused Jyoti Prasad Soikia, Soburuddin Ahmed, and Ravindra Narayan Deka, who have been languishing in jail since 26/5/2026 in connection with ACB PS case number 30 of 2023 under section 120B 406 409 ITC with section 13(1)(a) 13(2) of the Prevention of Corruption Act for grant of bail. Is to be noted here that above method question when registered on the basis of an FIR lost by one. Where is the FIR?
FIR notice will find that page number 28, madam.
Basis of one FIR lost by one.
Prosanto Borkatati, madam.
Prosanto Borkakoti, Managing Director, Assam Fishery Development Corporation Limited on 21/9/2022.
If Lordship will find the allegations at page 65, my lord. In the earlier bail order, the entire allegation has been reflected, madam. That can be reproduced. Page 65, para 3, my lord. Yeah.
The essence of allegation against the present accused persons are that they have misappropriated a huge sum amounting rupees 27 lakhs 8,719 rupees in the name of preparing detailed project works, project report for submitting to National Fishery Development Board without an instruction, and also caused loss of rupees 1,53,83,517 rupees for settlement of bill fishery without adhering to the principle of Government of Assam in the name of model bill, and also involved in transfer of rupees 11 crore 98 lakhs 48,619 rupees without inviting any tender of the development work to various persons in the name of stakeholder. And out of the said amount, a sum of rupees 27 lakhs 82,600 was siphoned off in respect of Borvilla Bill Fishery of Nalbari district. Learned counsel for the accused submits that the accused persons were arrested on
26/5/2026, madam.
6/5.
2026, madam. Forwarding report will also will find that
26/5.
2026, madam. Case 32.
2026 and 30th/5/2026. And since then, they are languishing in jail for last 69 days. And that their further custodial interrogation, no, custodial detention may not be warranted in the interest of investigation, and they will cooperate with the investigating agency, and therefore it is contended to allow the petition. By contrast, Mr. Barthakur has produced the case before this court and submits that in view of the progress received in the investigation of the case, further custodial detention of the accused persons may not be required. Having heard the submission of learned counsel for both the parties, this court has carefully gone to the petition and the defendants plus on record and also files the case diary with the assistance of Mr. Barthakur. Learned additional people. It appears that the accused persons are languishing in jail as it seems. For last 69 days, and that it also appears that the IO has achieved substantial progress in the investigation of the case. And in that way of the matter, their further custodial detention, in the interest of investigation, seems to be unwarranted here in this case, and therefore this court is inclined to allow this petition. It is provided that on furnishing a bond of rupees 50,000 each with one surety of like amount to the satisfaction of the learned special judge
Special Judge Assam.
Assam, the accused persons be enlarged on the CDB return.
I'm deeply obliged, madam.
In other matter also same order is to be passed.
My lord,
And for how many days you are behind the bar?
same, my lord, 69. Obliged.
May please, your lordship, that the additional affidavit that has come in the record, my lord. As per their letter, my lord. That is about page 24. And calculation sheet also they have annexed in the next page, my lord, page 25, my lord. That amount has already been deposited, my lord, before the registry of this honorable court. Calculation sheet at page 26, my lord. That is by as per our calculation which we have submitted earlier, my lord. The same amount as they have reflected, my lord.
No, same amount has been deposited before the registry of this.
Before the registry, my lord.
Now we have to close this IA.
My lord.
Since the amount has been deposited, you may file application for withdrawal of the same.
No, that will be, my lord. That is formula procedure we will have to follow, my lord.
Yes.
That we will have filing application before the registry, my lord, for disbursing the amount to us, my lord. Or this your lordship can also direct the registry to release the amount to the petitioner, my lord, on proper identification, my lord. That also this interlocal application can be disposed of by your lordship, my lord.
No, where is the averment that the amount has been deposited?
That we have said, my lord.
Where?
That my lord, the check is also annexed, my lord. Page 25, my lord.
Page 25.
Of the additional affidavit.
Okay. Okay.
There is accompanying the letter also there, letter at page 24, my lord.
Senior
Where
counsel,
this check was deposited with the registry, my lord.
senior counsel assisted by
J. Bush, your lordship.
G. Bosho, learned counsel for the applicant. Mr. Das submits that an affidavit has been filed after effecting service of notice by Dusty Mood upon the respondent, opposite party number 1. But the opposite party number 1 remain unrepresented today. However, Mr. Das, referring to the page number 25 of the additional affidavit, submits that in the meantime the respondent opposite party has deposited a sum of rupees 18 lakhs 90,511 rupees before the registry of this court. And since the amount has been deposited by the respondent opposite party, this interlocutory application may be closed by directing the registry of this court to release the aforesaid amount in favor of the applicant after proper identification. Accordingly, taking note of the submission of Mr. Das, learned counsel for the applicant, and also considering the facts and circumstances on the record, this court is inclined to dispose of this application by directing the registry to release the amount of rupees 18 lakhs 90,511 rupees deposited with it on proper identification within a period of 1 week from today?
My lord.
1 week from today?
My lord. Published to lordship.
May it please your lordship. But we have challenged the entire proceeding in this case, my lord, and notice was issued. We have taken step, my lord. And it was,
Notice served or not?
as per notice, my lord, note, my lord, address was not available,
Okay, you will obtain instruction.
lordship.
Heard Mr. Ali,
And,
learned
my lord,
counsel
one
for
thing,
the
my lord,
petitioner.
we may be additionally allowed to take dasti also.
Whether it is permissible in the criminal
Not
proceeding.
that.
Huh?
They can take steps to see concern also.
Is it POXO case?
No, no, my lord.
And then that they can take steps.
Private disorder, they are living in a same flat, my lord, due to some scuffle, my lord, FIR has been filed.
Oh, nice. Office note dated 38/7/2026 indicates that unserved notice returned with a report addressing not available RTS. Accordingly, learned counsel for the petitioner is directed to obtain instruction in respect of the address of the respondent and thereafter to take fresh step by speed post and also by usual process within a period of 1 week from today. Rest is the matter after 4 weeks. 4 weeks.
But the date is in trial court, my lord, date is on 11th, my lord.
What to do?
But may pay, my lord, before on 10, my lord. In the meantime, we'll take, my lord, step, my lord.
Pardon?
I am praying for listing on 10th, my lord,
At
and we'll take a step tomorrow, my lord.
10th of September.
No, my lord, this month. Case is fixed for evidence.
But would you be able to serve notice within short period?
Lord.
Okay, 10th.
If here in this case, we have the report from the OC concern. And as per his report also, one Monirus Jaman has received the notice. He is the younger brother of the
Informant.
Okay. That is also.
Okay, then we will appoint amicus. Heard Mr. Soduri, learned counsel for the petitioner, Mr. Borthakur, learned, no, Mr. Locker, learned additional paping for the state respondent. Mr. Borthakur submits that. Mr. Locker submits that. As per his instruction, notice was served upon the younger brother of the informant. But the informant remained unrepresented today. Accordingly,
Well, by register post, possibly the informant also, my lord. He received it on 31st possibly. Informant also by register post we took, my lord, that and acknowledgement possibly it is there, my lord. He received it
not
on
necessarily his instruction.
that to
received.
the PP office, another by register post, my lord.
Srimati Bornita Soduri be appointed as amicus to represent the respondent number 2. This is the matter on
My lord,
short date.
my lord, can I pray one with all respect, my lord? Here today was the date fixed for the victims, my lord. It is already been undergoing, my lord, the evidence, my lord. And tomorrow also for 2 other witnesses. So can I pray, my lord, if possible tomorrow, my lord, then victim statement, my lord, definitely within 1 month it has to be taken, my lord, as per the act itself, my lord. So for the other witness, my lord, if possible tomorrow, my lord,
TCL will be required to obtain the federal TCL.
we'll give the copy right today itself, my lord. PCR possibly not necessary because we are challenging the order by which it was day-to-day trial has been given. That's why we have come before this honorable court. So all orders are before lordship, my lord. If possible, because my lord, Victim
Tomorrow,
definitely,
day after tomorrow,
my lord, my lord.
day after tomorrow. Yes, is the matter day after tomorrow.
In the-
Reflecting the name of the amicus in the cause list. And also furnish the copies of the petition and the relevant documents to her well in advance.
this can be brought forward at least because
Is it necessary if it is against the order? It is
Matter.
not for quashing of entire proceeding, it is for order.
Part, day-to-day hearing. Much obliged, ma'am.
Well, if your lordship may kindly see the or, my lord, the TCR, my lord.
So your contention is that search sheet is submitted
Submitted,
and in the search sheet your name is not there.
not there. But only one, my lord, that's why, my lord, lordship may kindly have a look at page 24, my lord, of the charge sheet, my lord. Page number 24, my lord. Flag mark was, it was flag mark.
Hmm.
Lordship got, my lord.
Yes.
My lord, is paragraph 73, my lord.
Hmm.
That the complainant humbly prays that your honor will be pleased to admit this complaint in connection with this case and take cognizance in the case, and after recording the statement of the listed witness, be pleased to punish the listed accused person, Nityananda Singh, Vinay Kumar, and Rajnikant Kumar for violation and contravention of the act, my lord. My lord, my name is not Nityananda, Vinay Kumar, or Rajnikant, and the petitioner before your lordship is Dilip Devnath. Now your lordship will see the prayer, my lord. Second, my lord, Roman 2, my lord.
Hmm.
That your honor be pleased to issue summon / warrant of arrest against Anil Yadav and number 2, Dilip Devnath. He is before your lordship. Dilip Devnath, due to their non-cooperation in the instant case, as they did not turn up for examination before the investigating agency. The prayer was made that a summon or a warrant may be issued. My lord. Till then, nothing has been issued against us, my lord. But I came here because the 67 notice has been served, my lord. I want to appear before the investigating agency. My lord. Some protection, my lord, that much, my lord.
The first is this lordship, I would take your lordship to the NIQ one of the petition.
Page 15.
15. Lordship will come to the second paragraph. It is submitted that during the voluntary statement of Nikanda C, recorded on 73/24, in which he disclosed that he was trafficking and going to be delivered the seized drugs to receiver namely. Now, he is the suspected receiver. Now, I'll take your lordship to the offense report submitted, record. Lordship is it's flag mark. Page 19. Its complexity is date lordship. It's mentioned there in paragraph 52. And also in page 20, he was in touch with the other accused persons. And lastly, though notices were being continuously being issued, he never turned up. And as such, the last name was picked.
No, he had not appeared before the investigating agency. That is a different aspect. But whether any material is there against him.
So the material that has come out from the other accused, that is why we want to have a statement. He is purported the receiver as per the other accused. Now, if he does not come forward, we are not able to come to a conclusion because he is His complicity comes from the statements of the other accused. That they were carrying these materials and he was the supposed receiver. That your lordship is in paragraph 52. That is not named anywhere. It's not correct. He is there. But we have not been able to catch hold of him. And rightly, the trial court had refused the main application filed before the trial court, lordship. That is it, page 17 of the petition. Trial court had taken note of the offense report, which is before your lordship. Trial court order, lordship, is page from page 17 onwards. And here, page 19 onwards, from paragraph 7.
No, is it the requirement that unless his statement is not recorded, you are not in a position to file search sheet or complaint against him?
Now, it is the statement of the other two accused, lordship. I would humbly submit that he may not be. Let's take an extreme case. He may not be. But then he will be let loose. The apprehension arises.
No, now the position become different. You see, you have filed a complaint.
Lordship.
And whether trial court has taken cognizance against him.
Lordship, that is what I'm coming to, lordship. Lordship will see page 19 onwards.
Then on what basis the trial court has rejected his bail application?
I'll just read out, lordship. From page 19.
Page 20.
I'm reading from page 19, lordship, paragraph 7 of that order. Well, the learned standing counsel submits that the case involves commercial quantity of contraband and therefore the readers of section 37 NDPS Act will apply to the present petitioner. He further submitted that during investigation, the intercepted accused named the present petitioner as the intended receiver of the seized contraband. He further contends that follow-up action was conducted at the petitioner's address where he was not found, and his house was found locked. Notices under section 67, those are laid out court, were also sent to him, but the petitioner deliberately failed to appear before the investigating agency. Further, the CDR analysis reveals telephonic linkage between the carrier return of the same supplier, Vinay Kumar Associates, and the present petitioner. Therefore, the learned counsel for the NCB contends that the case is not solely based on the disclosure of corroborated by other incriminating evidence. The learned standing counsel for the NCB further submitted the offense report. In this case, has already been submitted with a prayer before this honorable court to issue warrant of arrest against the present petitioner. Under these circumstances, lordship, the bill was rejected because there was some material.
No, my lord, last paragraph, kindly read the last paragraph 10 is important, my lord. Paragraph 10 is important.
The court finds that there is no dispute regarding the fact that seized quantity of contraband in this case is of commercial quantity, has the twin conditions under section 37 has to be fulfilled. This court is of the considered opinion that in the instant case, the twin conditions are not satisfied. That is, the court is not satisfied that no reasonable ground exists to believe that the petitioner is not guilty, and while on bail he will not commit similar offenses. Accordingly, considering the seriousness of the offense, nature of the materials collected, and the statutory embargo under section 37 of the NDPS Act, the court is considered a view that anticipatory bail ought to be rejected.
Well, I want to appear, my lord.
You want to appear before the trial court?
No, my lord, before the investigating agency, my lord. Because trial court, my lord, in the charge sheet, I have not been named. And they made a prayer, my lord, to issue summon / arrest of warrant. But till that, nothing has been done, my lord. So far that, my lord. So if 67 notice, I want to comply, my lord, only some protection may be given. That much, my
No, the problem is that
lord.
in the complaint, you are not named
But not
actually.
named.
The reason shown by them is that you have not complied with section 67 notice.
Yes, my lord.
So since the complaint has been filed,
My lord.
can we direct you to appear before the investigating agency?
Because, my lord, that notice still remains, my lord. That 67 notice, my lord. And well, otherwise also, my lord, in for the prayer, my lord, it seems, my lord, they prayed to issue warrant of arrest or issue summon, my lord. Well, nothing has been, no summon has been issued to me. And
No, unless you have been arraigned as an accused,
my lord,
how can the investigating agency make such a prayer?
yes, my lord.
You have not indicated his status in the complaint as either as witness or as accused. Had it been the case of accused, then okay, all right, we could have directed the trial court that yes. So now what to do? You see the precarious situation.
My lord, actually, my lord, to be fair enough, my lord, well, he shouldn't have moved the trial court, my lord, for bail, my lord. Why he moved the trial court, my lord? Because no summon, nothing has been issued, my lord. But
If that would be off the records, but if I have to make a submission, motion, let him appear before the
Authority. But the authority to direct him appear before the authority, the case has already been submitted to the trial court.
But then there is a statement that he is absconding in the office report. There is a statement that he is absconding. There is also a statement that the other accused persons have named him. Since he is absconding, there's a statement. And there is also a prayer to issue a warrant of arrest. Worship may consider it. Perhaps I'll leave it to your worship. But yes, he did make a mistake. I appeal.
and one of the other
Then
three,
admittedly till that no warrant of arrest or
No,
any
ma'am.
notice was issued
No,
by the trial
no.
court.
and the other three, my lord, the main accused, my lord.
That being so, where is the apprehension of arrest?
But that's why, my lord, I have, that is the wrong, he has moved the trial court, my lord, for bail, my lord. And that bail was rejected.
Or at best, personally, that is my view. I do not think he has any apprehension. Only because it was rejected, he is here.
That's right.
Withdraw this, perhaps.
No, that,
This petition?
no, man, no, that bail was rejected, no?
That was rejected.
No, one thing is there, that decision of Supreme Court in Gurbakh Singh case.
My lord.
So even if no FIR is registered, then also court can grant
That is.
here over him the sort of Damocles is hanging, the warrant of arrest.
That is a position he himself has created now.
And the arrested accused are on bail, my lord. Although they are facing the trial, my lord, let a witness. 3 witnesses already examined.
Okay, let us do one thing. You have submitted that you may be allowed to appear before the IO.
My lord.
And till then, no coercive action should be
My
taken
lord, my lord,
against you.
my lord. I'll be highly obliged. my
In
lord.
that line, we will
My
dispose
lord,
of
I'm
this.
highly obliged. Deeply obliged. I'm obliged.
Coming item 36.
We have received the updated case diary.
Hmm.
As per the case diary, Pranab Kutum and Sanjit Kutum, they are absconding. They do not have any hearing also, but they are not appearing before the IO.
Sanjay Kutum is on interim and he is already appeared.
As per our system, he has not appeared. I don't see.
Kiran Pegwai, one of Pegwai, interim councillor, Sanjit Kutum, select.
What is the allegation against you?
Allegations. Lordship, under section 939, 44 and 51 of wildlife process. Rhino horn.
Whether any rhino horn was recovered?
No, no, sir.
Rhino nails were recovered earlier, my lord, from Pranab Kutum's house. One of the
In 2019.
Lordship,
In the year 2019.
19 years, Lordship. But not
No,
in that.
this time whether any substance was recovered, incriminating
In
substance,
this case, recovery has not.
not been
Not.
made.
But these two applicants, my lord, Pranab Kutum and Kiran Pegu, another earlier case in 2019 is already registered against them for recovery.
Maybe, no,
rhino
no.
nails were recovered.
This application is in the present case, not in the earlier case.
No, Lordship, not. Nothing is
Earlier,
recovered.
not in the.
Not, nothing is recovered in this case, Lordship. They are not main accusers.
Let them go on bail. Pardon me?
Lordship. A. Gogoi, on behalf of
Learned
Chief,
counsel preparing on behalf of Mr.
Chief Con.
Learned counsel for the applicant and also heard Mr. I. Thakur, learned standing counsel for the forest department. Apprehending arrest in connection with offense number CIR stroke 03 of 2025. Dated 31st/12/2025 under section 9, 39, 44 and 51 of the Wildlife Protection Act 1972. This application is preferred by applicant Parnab Kutil for grant of Pierce bail. The essence of allegation, no, it is to be noted here that above noted case has been registered on the basis of one complaint lodged by on the basis of one complaint lodged by whether offense report is submitted.
Lordship.
Offense report,
Report against them should not be submitted because they are absconding, ma'am. They are not appeared
Yes.
before that. Only in AD 1311, my lord, that applicant has appeared before I.
At any condition, Lordship.
who lodged the complaint?
Deboram Tide FI, Investigation Officer, Crime Bus Range, Ranger,
Page number
14 Lordship.
on the basis of one complaint lodged by Deborah
Tide.
Tide,
Mm.
Forester 1,
Forester 1.
Forester 1. The allegation against the present applicant is that along with one deposit pego, he was supposed to do a transaction of rhino horn at Gauhati. And that he and one Kiran Pegu were previously involved in rhino poaching at Lahora, Sapuri of Gopur during 2019. The learned counsel for the applicant submits that the applicant is innocent and no way involved with the offense alleged in the FIR, and that the arrested person, namely Deposit Pegu, is the relative of the present applicant who stayed in the house of the applicant prior to his arrest. And the applicant is ready to cooperate to the investigating agency, and therefore it is contended to allow the application. The learned standing counsel for the Forest Department, however, opposed the petition on the ground that after arrest of the accused, Deborah, after arrest of accused Deposit Pego, the present applicant has been absconding, and as such, his statement could not be recorded. And that earlier he was involved in the rhino poaching in the year 2019. However, he fairly submits that nothing has been recovered from the arrested accused in this case. But having heard the submission of learned counsel for both the parties, this court has carefully gone through the petition and the documents placed on record, and also files the case diary produced before this court by the learned standing counsel for the Forest Department. In view of the materials collected so far, in the case study and also in view of the nature of accusation. And further considering the fact that nothing has been recovered from the position of the arrested accused. This court is of the view that custodial interrogation of the applicant seems to be unwarranted in the interest of investigation, and accordingly this court is inclined to allow this petition. It is provided that in the event of arrest of the applicant in connection with case number so and so, he shall be released on PRS bail on his executing a bond of rupees 10,000 with one security of like amount to the satisfaction of the arresting authority. The above privilege is however subject to the following three conditions.
Same
Okay.
same lordship, 38 is already interim lordship. Obliged lordship, highly obliged.
40. Okay, my lord, in this case, against the present petitioner also, search submitted on 27/7/26, my lord, initially against other accused persons. My lord, search submitted on 36/26. Thereafter, my
No, he is on interim bail.
Yes,
He appeared before the IO.
I'll appear.
You appeared.
I have appeared before IO, my statement also recorded. Now, since it
Now,
is charged,
Thursday we submit.
I'll appear to the court. My
statement against him, search submitted. my lord.
Search it submitted. So you go and apply for regular bail.
I'll appear.
Heard Mr. Business Learned Counsel for the applicant and Mr. Portakur Learned Additional People for the status bond. Apprehending arrest in connection with Borpeta Road PS case number 38 of 2026 under section 3 and 4 of the Immoral Traffic Prevention Act, added section 6 of IT, whatever P Act. Its application under section 482 of the BNSS 2023 is preferred by applicant Nathuram Mandal for grant of PS bail. It is to be noted here that above noted case has been registered on the basis of one FIR lost by one. Who lost the FIR?
Chaudhary, Prakash Chaudhary,
President of
Rashtriya Bajrang Dal.
One Prakash Chaudhary, President of Rashtriya
Bajrang
Bajrang
Dal.
Dal
On my lord, 22/4/26.
24/4/2026. The allegation against the present applicant is that he is involved with involved in bringing women to illegal activities in Moyur Dhaba situated at Kola Banga near NH 27 under Borpeta Road Police Station. Where they have been involved in carrying out illegal activities. Mr. Biswas Learned Counsel for the applicant submits that the applicant was granted the privilege of interim PRS bail by order dated 30/6/2026. And pursuant thereto he had appeared before the IO and his statement is also recorded. And he has been cooperating with the investigating agency and therefore it is contended to make the interim order dated 30/6/2026 absolute in the same terms and conditions. By contrast, Mr. Bortakur Learned Additional PP submits that the IO has completed investigation in the meantime and submitted charge sheet against the present applicant also. Under the given facts and circumstances, this court is inclined to dispose of this application by directing the applicant to appear before the learned trial court and to apply for regular bail. And in the event of filing such an application, the trial court shall consider the same in accordance with law. On or before
19.
Till then, interim protection granted to the applicant by the order dated 38/6/2026 shall continue.
Diploma.
Pending 41.
May please, your lordship. FIR is at page number 13. At page number 13 is the FIR, my lord. Cough syrup of codeine national has been seized from my pharmacy as well as from the godown, my lord.
The question is whether
My lord,
under the cases, in the cases under the NDPS Act, the PRS bail application is maintainable.
my lord, so far the allegation is concerned, my lord. Codeine has been recovered and so far I have a license, my lord, to restore or store sale, my lord. And so far the restricted items, my lord, drugs, which are restricted for me to not to restore, which is reflected in the license, my lord, is of Schedule C, C1 or X, my lord. And if I am not wrong, my lord, codeine is of H and H1.
Codeine is?
H or under Schedule H or H1. My lord. And I have all the documents of purchase along with the GST paid, my lord, which I have annexed, my lord. But the thing is that when, my lord, the raid was made in my pharmacy, my lord, and these are seized, I was not in my pharmacy, I was in another place. So I could not produce those documents. And even if the syrups I have already been sold out, my lord, all has been maintained in a registered, my lord. I could not produce those the registered because that was whole the pharmacy was, my lord, locked. So at this stage, my lord, even if I get an opportunity, I will produce all the documents, including I have annexed the bill, my lord. The other thing, my lord, regarding the maintenance of register, regarding the sold.
No, the
Yes, my-
question is before passing such an order, this court has to satisfy itself that it has the jurisdiction to grant the privilege of PRS bail.
Recently, my
NDPS
lord,
cases.
recently, my lord, in a similar case, my lord, anticipatory bail has been granted by a coordinated bench of this honorable court. I have the order, my lord. If your lordship, please, my lord.
You can go to that court then. Or you show any authority that this PRS bail application is maintainable. Mr. Bortaker?
Yes.
PRS bail.
But he not only was continuously involved in selling on those items, but one of the employee. So regarding therein, otherwise also this is not a fit case for granting it.
No, I have, my lord, I have the license to store and sell this kind of drugs.
Only having
And
the
I-
license is not sufficient. Whether you
I-
are permitted to sell
I-
not any prescription goods, but whether you can keep it.
I have,
When items for
but I am submitting that only.
not
That
only
also.
from his mail pharmacy, thereafter only taken by his employee from his down also.
But I have legally purchased those drugs, my lord. I have the bill, my lord. I have annexed with this petition, my lord. And all the selling I have been maintaining registered, my lord. But the thing is that my pharmacy has been seized, my lord, sealed it is. So I could not produce that. Otherwise, I have the license to store. I have the bills legally purchased these drugs, my lord.
Okay, you show any authority that this petition is maintainable?
Then, my lord, your lordship may give me some time, my lord. Because today
On
on
the
that,
pair being made by Mr. M.A.I. Hussain, learned counsel for the applicant. Recessal leaves the matter on
on
Fine.
Friday, my lord.
Friday, so as to enable him to produce any authority before this court in respect of maintainability of an application under section 482 of the BNSS 2023. While commercial quantity of contraband substances were involved. List accordingly.
All right.
None appears for the applicant on call is the matter after 3 days. In the event of subsequent non-representation, appropriate order shall follow.
Item 25 for admission. Order date.
With the cases, Your Lordship, in this matter, Your Lordship, age currently is appearing on the last patient. She is falling, Your Lordship, having viral fever, Your Lordship. She will not be able to come, Your Lordship. On behalf
No,
of
no,
our Your
you could have obtained the instruction here.
Here, Your Lordship, our affidavit is not yet, Your Lordship, filed, Your Lordship. So I.
No, why your affidavit is
Yes, Your
necessary, you comply with the order.
I need to obtain instruction, Your Lordship, since here affidavit is not yet filed. So kindly, some time may be granted.
Why
Your Lordship, to
affidavit
file that.
is necessary? So the person concerned has already retired. When retired?
Is it 31/2016? 31/1/2016.
His
26.
his appointment later regarding the date and issuance of his acceptance. So this. is
No,
the
on
fact,
several
Your Lordship,
occasions,
we need to bring it on the
those
record.
documents were forwarded to the department. Hmm. So after the retirement, this is nothing but an harassment.
And during my tenure as a regular principal lordship, I did not get the scale of principal lordship. And even after my retirement lordship, pay protection has been not
Your
been.
Lordship, there are
pay protection
certain
has not been
facts, Your
given.
Lordship, he has raised it, Your Lordship. So not only one boundary, Your Lordship, there are several, Your Lordship, perspectives there. So. we
What
need-
several perspective is there?
Lordship, his.
She has been
retirement
appointed as regular principal.
benefits is also there, and Your Lordship, he is regarding the date. No, regarding the date of his appointment and joining, Your Lordship. So this is the factors, Your Lordship, here we needed to bring it on the records, Your Lordship. For that, Your Lordship, we needed to.
No, her entitlement is not disputed.
Yes, Your Lordship.
So you release it as soon as practicable.
Your Lordship,
How long she will fight?
fresh status, up-to-date status report, Your Lordship, I needed to bring, Your Lordship.
Because of this hide and seek game,
Yes, Your
your department has not been enjoying any good reputation. Today you are engaged here. Tomorrow someone else will be engaged.
I'm here, Your Lordship, praying on behalf of age therapy, Your Lordship. Because of she's feeling sick, Your Lordship, viral fever is going on. So Your Lordship, pertaining to that ground, Your Lordship, I'm seeking adjournment on behalf of her. On the last occasion, she is appearing.
Heard Mr. Das, learned counsel to the petitioner. Miss P. Das, learned standing counsel appearing on behalf of Miss S. MP. Learned standing counsel for the education department. Submits that Miss Terampi is indisposed of, and as such, she applies for listing the matter after 2 days.
Your Lordship, Monday.
Monday.
Lordship will fix it for final disposal, lordship.
Monday. It is provided that on that day, the learned standing counsel for the respondent authorities shall remain present with all requisite information. And in the event of failing to do so, this court will consider directing the respondents to remain personally present before this court on next date.
Preparing for the finance department of for respondent number 3. Their lordship, we had received the proposal, lordship. We are not, we were not disputing. Only the issue was when they had sent the proposal, lordship, regarding the date of appointment, there was a discrepancy, lordship. That instruction, if it is produced, lordship, I can state it on our affidavit also, because they will be entitled to their benefits from the date of joining.
Monday, Your Lordship.
Yes, and they are not seeking it from another date.
Yes, yes, your lordship. So, at
appointment.
That, Lordship, so our hands are tied at this moment because only when the proposal comes, we will provide the necessary.
See, I went to join on 16/9. 16/9, Lordship, the inspector of school was not available in his office. Then he came back, Lordship, on 19. He allowed my joining in on 19. Now, Lordship, if your Lordship holds,
Oh, okay, you allow it from 19.
if your Lordship holds on 19, Lordship, then there will be a service break, 3 days service break. My successive appointment is extended as subject teacher. Either Lordship 16 or 19, Lordship.
16 or 19.
And regarding that.
No,
Lordship,
okay, notionally that benefit can be given.
That, Lordship, we, from our end, we just need the documentation. That is all. From there, we can take the necessary action. The issue is.
No, now the matter is pending with the finance department.
No. It's with the education department because of the discrepancy regarding the date of appointment. That 16.
No,
No,
that
that
has
was joining.
already been,
Date of joining,
Yes.
regarding date of
no,
joining.
that has already been clarified by the inspector of
Inspector,
school.
Lordship.
A letter was already sent to the director.
Yes. So from there, Lordship, if the.
Lordship, I will obtain
Only the
it.
proposal needs to go, then Lordship.
Up to date instruction whether your lordship that 16 or 19 which has given your lordship forwarded to DSC later. Your
Okay,
lordship
on
regarding-
Monday,
Yes,
uh,
your lordship.
if you fail to obtain instruction, we will direct
Disposed of, your lordship.
direct the other side,
Yes.
direct the respondent to remain personally present in the court.
Hearing official. But the hearing
Your lordship,
official.
I will obtain instruction.
Lordship will direct the hearing official to be personally present.
Not any official, we are not conducting any inquiry, who is responsible?
Yes.
We are not fixing the responsibility. We direct the respondent authorities who are here, who are arrived as here.
Yes, Lordship, but.
Mr. S. Alia for the respondent number
16 আছে, কিমান আছে দা?
16.
আপনি-
Sorry, on 10.
Appointment.
Any other matter?
Appointment.
Obliged.
DP office.